I'm a beautiful disaster, a reckoning. You wonder how I got this way. You think I'm someone to be saved, someone to clean up and tame. Oh, some things never change, never change. You think I would look pretty on your arm once you cover up my bruises and battle scars, but it always ends the same. Can't bear the things I've had to face, got you crying on your knees in pain. Oh, some things never change, never change. You'll break your back to make me feel again, suffocate to make me breathe again, lose your mind from endless pain. Some things never change, never change. Redemption never came. I stopped asking for forgiveness, cause you should know only fools tread where the angels fear to go, but you keep trying to get too close. Save myself by turning into stone. So
Welcome back, members of the jury. We will continue at this time.
Thank you, Judge. Randy Beasley.
Randy Beasley. Morning, sir. Could you please come forward? I'm going to face my clerk and raise your right hand to be sworn in.
Do you solemnly swear that the testimony you have given in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Thank you, sir. Have a seat there at the witness stand. And as best you can, if you speak in the microphone. Thank you. You may depart.
Thank you, Judge. Sir, can you say your whole name and spell your last name?
Randolph Beasley, B-E-A-S-L-E-Y.
Mr. Beasley, are you employed?
Yes.
Can you describe your employment in your company?
I have a forensic consulting business. It's called Seek First Forensic Consulting, and I've had that for over 10 years now.
Do you have any qualifications that enable you to have a company like that and a background like that?
Yes, I worked for the San Bernardino County Sheriff's Department Crime Lab for 30 years. The last 19 of those 30 years was in the crime scene investigation unit. And so the experience and training investigating about 300 homicides, teaching classes and bloodstained pattern analysis. And so that training and education was hundreds of hours of specialized training in the forensic science field.
So in terms of crime scene investigation, with the last 19 years being a part of that unit, did you actually go to crime scenes?
Yes.
All right. Did you actually take evidence at those crime scenes?
Yes.
Did you actually develop theories about what may have occurred at those crime scenes?
Yes.
During your career working for that department, did you eventually develop some expertise in terms of blood stain analysis?
Yes.
Can you walk us through that, please?
Bloodstained pattern analysis is part of what is used to do crime scene reconstruction, to determine what happened at any particular incident. And so it can assist in positioning where a victim would be, where anybody who has had blood shed from their body, if they were moved, if they were not moved. So a sequence of events sometimes can be occurred, or determined rather, and so it's an important part of crime scene reconstruction.
All right. And can you describe for us the sequence of trainings that you had throughout your career that allows you to opine about blood stain analysis?
Yes, so in 1990, I believe was my first bloodstained pattern analysis class. And at that time, the Sheriff's Crime Lab did their training in-house. So Cal State Long Beach was some of the basic training that covered a little bit of bloodstained pattern analysis, but our particular crime lab used several different criminalists to train the forensic specialists and crime scene specialists, which was my position, in the field. And so we would do other training for other departments in our regional training center as well. And then part of my training was to attend conferences by the International Association for Identification, also just abbreviated IAI. And so I would attend conferences, specialized training with bloodstained pattern analysis, and then certain 40-hour classes. So a lot of training, which then really kind of got nailed down or reinforced with a 2-year mentorship program by our crime lab director at the time, specifically in bloodstain pattern analysis at actual crime scenes and then doing reports, et cetera.
And did the end result of that mentorship, as well as this other training you've talked about, result in you becoming certified in some fashion with bloodstain analysis?
Yes, the IAI has a bloodstain pattern examiner certification back, I think it was 93. So for 13 years of my 30 years at crime lab, I was a certified bloodstain pattern examiner through IAI.
And did you use that knowledge in these 300 investigations of homicides that you've described to us?
Yes.
Have you also utilized that knowledge about bloodstain analysis in terms of presentations?
Yes, I do a lot of presentations. I've done presentations back when I was working at the crime lab. The crime lab director and I did a specialized training for San Diego County Sheriff's Crime Lab on bloodstain pattern analysis and documentation. I've lectured at the IAI conferences now, and still do that even as I retired in 2007 as part of continuing education.
Okay. Have you testified before on bloodstain analysis?
Yes.
Whereabouts?
I've testified San Bernardino County, Superior Court, Riverside County, Los Angeles County, here in Idaho, Ada County, and then here in, is it Kootenai?
Kootenai.
Okay. So Kootenai County, that's a local state, okay. And in Nebraska, I testified for the United States Air Force in South Korea, and as well on a bloodstain pattern analysis case.
So in these different jurisdictions you've described to us, has that been, at least in part, in bloodstain analysis?
Yes.
And so you have testified before as an expert in that particular field?
Yes.
Okay. In terms of bloodstain analysis, is there kind of a starting point when you're talking about directionality of blood flow?
Yes.
And can you just give us a summary of what that entails, please?
Yes, there's a recommended list of terminology within the bloodstain pattern analyst community, and that's been changed over the years, but directionality is pretty much agreed that it's the direction of travel for any particular bloodstain. So when force is applied to blood, whether it's a blunt force trauma, whether it's a gunshot, that'll cause blood to be spattered into smaller stains as part of the overall pattern. And where you can determine, using directionality of small stains, you can determine where that area of origin occurred for the blood shedding event. And that's all using directionality.
Okay. And I think this is going to become evident as you talk a little bit further, but can gravity also play a role in directionality?
Yes.
Okay. I have a number of exhibits here. I'd like to show them to you. May I approach, Judge?
Yeah.
We can label them as 55A through G. Let me just go through these a little fast and then ask a couple questions again. That was 55B, 55A, 55C, 55H, 55B, 55B, 55F, and 55G. Do you recognize those exhibits?
Yes.
Now, some of those exhibits are exhibits that would be demonstrative, in other words, exhibits that would help you testimony here today. Is that accurate?
Yes.
And then others are demonstrative end of Kendy Howard. Is that correct?
Yes.
Will these exhibits help you with your testimony here today?
Yes.
And are these exhibits accurate as it pertains to the evidence and process you want to describe us today?
Yes.
Move to amend 55A through G.
Any objection?
Yes, Your Honor, as to, no objection to demonstrative, but objection to amending into evidence.
On all of them, or do you have specifics?
Yes, may we approach?
You may. I did exhibits for demonstrative purposes, meaning witness can use them for presentation to the jury. And we're certainly ruling on whether or not they'll ultimately go back to the jury's findings. So, at this point, approved for demonstrative purposes, and publish them as seems appropriate as part of this testimony.
Thank you, Judge. So, Mr. Beasley, in terms of directionality and your explanation of blood flow as it pertains to that, let me show you 55B. Take a look at that and explain for us what that image shows.
Sir, while looking at that image up, I'll just tell you, if you need to step out into the well to look at it, please feel free to just speak up loudly because you won't be captured by the microphone. Or if you're able to see it from right there, that's fine as well.
You bet, thanks. I think the judge's suggestion would be a good thing for me to explain if there's a pointer or something. Okay,
So, what are we looking at here, Mr. Beasley?
so this is a slide from a blessing pattern analysis class that I teach at a local college as part of their CSI program to demonstrate that when blood is in flight from gravity alone and you create a drip stain, the drip stain, when it hits a target, will have a certain shape. And you can see this here, where the red arrows document that the stain is hitting this target, which is just a white piece of paper, as I recall, in a downward direction. So if you see the serrated type edges here on these stains on the left, there's two stains that don't have quite the length of a tail to show that direction, but the more elongated stains do. And so gravity's effect, so no force applied to blood, just blood dripping, can show the direction from where that blood stain originated. So in this case, the blood stain would have originated above the screen, so that when it contacts this target, you have an elliptical shape where it first makes contact, and then you have this tail, if you will, that shows that direction. Of course, the more elongated stains would show this, and then because of gravity now, you can kind of see how at the tail end of this stain it's a little darker. And then at the end of this tail, gravity's effect has caused a little pooling, if you will, where the flow continues and stops. More blood is accumulated often at that tail. And so where the flow stops, in this case, just directly down.
All right, so this directionality exhibit that we're looking at, would this be on a piece of smooth paper as opposed to textured paper?
Exactly. So when the surface is smooth, you have a very well-defined elliptical edge. But if there's drip stains or spatter stains on a rough textured surface, like drywall, or any rough textured surface, could be a rough surface of someone's skin, then you'll have a different appearance.
All right, let me show you Exhibit 55A, and perhaps you can describe what this shows on a textured surface, please.
So in this case, the textured surface with, again, just drip stains from a little pipette, there's no well-defined edge. It's the same directionality from top to bottom in this exhibit, but there's 4 different drips of a simulated blood source that are going from top to bottom on this textured surface. And you can see that sometimes it's based on the surface, like with stain number 2, it's just a little touch, several different smaller stains as contact with that, from gravity, that spatter going downward.
All right. And so when you have a change of direction, is that obvious with directionality of flow of blood?
Yes, and that change of direction, we call that a flow pattern. So if something is moved that has blood on it, and the blood is still wet, then if that object or item is moved, then you can have, not always, but you can have a direction. It all depends on the volume of blood, the direction being changed. So in this case, I rotated.
For the record, it's 55C.
So 55C, this different exhibit, so when I rotated it 90 degrees, now you'll see in stain number 1, there was enough volume of blood, and this is just a by chance situation with a drop of blood. In these 3 drops, number 1, the gravity's effect caused that volume to then change direction. So when I moved that piece of plastic styrofoam type material, it then did a right turn, and gravity took it down toward the ground.
All right. And are you able to show us how this change of flow pattern would change based on gravity using both a smooth piece of paper as well as a textured exhibit?
Yes.
Okay. And so I've got a smooth piece of paper here. It's been labeled as 55H. I think you brought with you a textured exhibit as well. With the court's permission, do you have the ability to show us how you could get a change of direction in terms of blood due to gravity with a blank piece of paper as to be illustrated by 55H?
Yes.
So again, with court's permission, what I'd like you to do is utilize what you need to utilize and show the jury how that principle works. Okay?
Yes. Okay.
May I approach, Judge?
Any objection?
No, Your
Okay, so Mr. Beasley, I'm going to approach with 55H. If you want to start with that first, which is a smooth piece of paper,
Okay.
and then move on to show the same thing with 55G, which is our textured piece of paper, okay?
Okay. I'm getting some nitrile gloves on, just for the record. and I have a fake blood source that I have in a plastic dish. And I have a small plastic pipette that I use for experiments and demonstrations. And let's see, what would be the best spot?
How about right here?
Okay. Well, that'd be great. In front of the jury to see, that would be ideal. I'm going to get some paper towels to spread out here.
For anyone struggling with high blood sugar, do not drink cold water.
Okay, so exhibit 55H is labeled as flow pattern of blood stain resulting from the movement of the volume of blood on the surface due to gravity or movement of the target. And so what I'll first do is I'm holding the pipette about 18 inches above the target so that I can create some drip stains to show that directionality. You can see with the smooth surface, that elongated stain. And then if I rotate it, and we'll see if there's something that has enough volume. See how that is, there's not enough volume yet to make that flow? So I'll do another stain. So there's about, I think 5 drip stains, and you can notice, maybe before I do this, can I show the jury these little?
You may.
Okay. So just with a few stains, one missed, so we've got 5 here, but what I wanted you to observe is to see the smaller stains. We call that satellite stain. These small stains have directionality as well. And again, I'm holding the target in an upward position. So when force is applied to blood, or if there's other issues, you'll have these smaller stains. So again, let me add a little more volume of blood with another stain. I'll make this one off to the right here. So I had another 5 stains, and as I rotate this, if I then move the target, rotate it clockwise, you'll notice that nothing's really flowing yet. So we'll get a little more volume. I think the paper's absorbing it a little bit. So if we do, well actually, let's start to. You can see it start, right? Let's add a flow of blood this way. So if someone is a source of blood, if someone bleeding, let's say, and as the blood is coming out, and then it's turned, now you notice the gravity's effect, okay? So it all depends on the surface, how much volume, but the point is, for this flow pattern, is now you have a change of direction. And it's all confirming that something was moved. So I moved this target. When I first had it, it flowed downward to gravity, so now I rotated it, and you'll see that, as you see this, you notice the larger, or the increased volume at the end of that stain. See how it's darker? There's more blood there. And so when this dries, that will be a little darker because of the volume of blood, and it stops at the point where gravity is not affecting it. So we can let this sit and dry.
All right. So is there a difference between a smooth piece of paper and a textured, say, piece of paper or material when you're talking about directionality and flow and a change in it?
Yes, it'll have a different appearance.
Can you do the same thing you did with that particular exhibit with a piece of textured material?
Yes. So exhibit 55G is a similar type of textured material that was in the slide presentation. So here I'll do the same thing in 55G, where I will take several, I'll work on my aim today, okay? So what you notice is, you notice that the certain stains, and again, if we rotate it, I've taken this exhibit, I've rotated it, and you can see that some of the stains have pulled up at the end of that pattern. And so now, just like with that exhibit, there's a volume that you can see that gravity's effect now, because of time, you'll notice this one here just made that right turn, okay? So this confirms that I moved it. I mean, there's no doubt, you saw it. That's how gravity works. So here you have this right turn, but you see how it's not as clearly defined on the edge. There's not an elliptical shape to it like with a smooth surface. And so you'll have where it touches and makes contact. The more textured the surface, the more you're going to have little dots to show where that stain traveled. But even though it was moved, not all of the stains moved, because that's just the chance of how much volume of blood was in that flow pattern now. But this one here, it's very obvious, it made a right-hand turn. And it's because I rotated it. So we can let this dry.
Okay, thank you. And we've got another demonstration, but I'd like to have you talk about a few things first, if you don't mind. So if you could take your seat again. So you've kind of described here direction of flow in terms of both a smooth surface and a textured surface. Let me back up and ask you some questions about this particular case. Obviously, you've agreed to work on it for us, correct?
Yes.
What sorts of images and or other evidence did you look at in order to get prepared for your testimony here?
I looked at the crime scene photos, and I looked at the autopsy photos, and focused my attention on those, per se, especially the photos related to the victim's body in the bathtub, as opposed to other areas of the house, and focused on the blood stains that I observed and the flow patterns on her body.
All right. And did part of that flow pattern that you focused on concern her right breast?
Yes.
What was it about her right breast that caught your attention?
It was a change in a flow pattern. So her body, because of having on her breast blood on it, similar to the demonstration that I did, where the blood stain flowed differently. One particular stain made a right-hand turn showing her body was moved, and it was not in the position as it was photographed.
So you've got behind you 55D, and then in a minute I'll show you 55A, which is a close-up. But can you describe what you mean in more detail with 55D, please?
Yeah, if I could approach. Yeah. So this is 55D.
And the close-up, which is coming next, is 55E, so let me know when you're ready for that.
Okay. You read my mind. So there appears to be a stain that was traveling in the position of this red arrow that I placed to show the direction, just like on the textured material. But this one particular stain changed directions. I'm identifying it as the stain with the red arrow going more on the top of the photo, and then the arrow that makes this right-hand turn because of gravity's effect.
And then here's the close-up, 55E.
So 55E, you have one particular, this is consistent with a particular stain here, where it just made 3 little contacts. And then this one here, there's 1, 2, 3, 4, 5, 6 little touches to the surface of her skin on her breast. And then her body was moved after that stain, so that it's now did the right-hand turn, where you can see the more accumulation of the volume of blood again. At the end of that, where I'm indicating the darker, more concentrated area of blood on her breast.
Perhaps using 55E, you can tell us why it was important for you to describe blood flow in terms of a smooth surface and then blood flow in terms of a textured surface.
Exactly.
Is that because the breast, the nipple area there is textured?
Exactly. That's why I did the demonstration on the textured piece of styrofoam, just to simulate, in essence, a textured surface and what blood will do, and how, if I can show this again.
Please.
And so, again, exhibit 55G. So 55G, the stain that I'm indicating that has the right-hand turn to it, you see the volume at the end of that stain where it stopped, and it's going to dry. And probably by the time you get it to evaluate it, it probably will have flaked off maybe, but at least you can see that. And that's what you have on the exhibit with her right breast.
So let me lay a little bit more foundation for this next part of your testimony, Mr. Beasley. Shouldn't take too long. You've described for us kind of the illustrative exhibits used to describe directionality and the texture as it pertained to Kendy's breast, right breast. Are you able to do the same with her face?
Yes.
And in terms of her face, did you notice a change in directionality in terms of the blood flow from her mouth and nose?
Yes.
Okay. Let me, I think we've got one of these exhibits. Mark, kind of addition to what we're doing. So what I'd like to do is take, what I already have marked 55G, 55I, and then for the record, what's your name? 55I, in addition to the leader of the district.
So 55G is now, you're turning it into 55I.
Yeah, well, 55G is actually separate. 55I
Oh.
is still
I see. All right, so 55I was previously admitted as a different number. What was it called before?
55G.
I see, okay. So 55G will now be the demonstration exhibit. The photograph will now be 55I.
Yep.
Okay, I'll admit 55I is, it's previously been admitted, I'll just note the amendment.
Thank you, Judge.
Number of the letter.
Okay, so let me show you kind of the same thing that we did with the prior photographs. I'll show you one that's a little bit further away than one that's more of a close-up. The close-up, the one that's further away would be 55I. Take a look at that and, if you can, describe what you saw in terms of a change of direction in blood flow.
what I observed on her face was two flow patterns of blood. One that I initially thought was coming from her right nostril is actually coming from her left nostril. And the blood flowed across the bottom of her nose and then went upward against gravity in the position that which she was found on the outside rim of her right nostril. The same thing from what appeared to have been blood originating from her mouth, that there was a flow pattern that flowed across from her mouth upward on her right cheek. And again, this would not be consistent with having been created in the position she was found. Her head would have been in a much different position, flopped backward, to create those two flow patterns, which again would be consistent with her body being moved for that flow pattern on her right breast as well.
And then 55F. Same thing, just a little bit more close up. Can you see the same identifiers in that photograph as the previous one?
Yes. And what's observed here is the dilution of this flow pattern that went from her mouth here toward her right cheek, and then to where it ultimately ended at the darker dry blood area above the waterline. So what's visible here is that the water from the bathtub has diluted some of the stains on her cheek area, and has also started to dilute this heavier blood stain, the end of the flow pattern that you see here in between these red arrows. So the contact with water in the tub is starting to work this as well. And now you see gravity with the position that she's found is working so that that diluted blood is now going into the water.
Okay, so you showed us with prior photographs of her breast how her body had to be moved in order to have that change of directionality of blood flow. Does this indicate to you or not whether or not her head had to be moved in order to create that change of flow?
Absolutely, her head was moved to create that flow.
Are you able to illustrate that using one more exhibit and show how that is possible and how that had to happen?
Yes.
And can you describe for us what you have there and what you intend to do with this exhibit?
Yeah, so what I have is a styrofoam head of a female that I have marked with a little Sharpie to show the basic flow from her left nostril and then from the right corner of her mouth toward the area of her right cheek, as depicted in the photographs that we've just looked at.
Is your aim with your blood stopper up to reproducing how her head would have had to have been moved to show that change of flow?
I'll do my best about that.
So with the court's permission, let me double check on that exhibit. It's on the bottom, but I bet you I got it wrong.
55.
Yeah, so let's make it 55J. And can we do 55J?
55J, any objection?
For demonstrative purposes, no, Your Honor.
I'll know 55J as a demonstration exhibit. Also called demonstrative exhibit.
So Mr. Beasley, you've got 55J, which is a styrofoam head. You've got the other materials that you need. Can you show us how her head would have at least, in a substantial fashion, had to have been moved in order to recreate that change of flow?
Yes, and in doing experiments in this type of situation, I will do the best to get it right the first time, to follow the actual trail to be as similar to the blood flow on her right cheek as possible. So I'm now taking the blood, my blood source in the pipette, and I am going to put some of the blood onto, and show where I start here, the jury. So there's I made a little divot in the styrofoam head to kind of have the blood cool, and I'm trying to keep her position of the head, of the styrofoam head, so that gravity doesn't affect it. But if you see how it's cooled up there, in that little divot in the styrofoam, and then, just to show here. So again, if I were to put this styrofoam head in the position that she was found in the tub, it would run down her face toward her chin. But if her head is moved such that I'm now rotating it from a horizontal position, and I'm rotating it again, I'm flipping her head backwards, in position backwards, and may have to add a little more blood, but we'll see what happens here. I can see gravity, the surface tension of is preventing it from moving, and we'll see. Okay, so I'm tipping her head back more. I'm rotating it clockwise. Okay, let me add one more drop. This is like real life crime scene, let's say training here. So you add a little bit blood, a little bit more volume. Okay? So now I'm going to tilt her head back again, the styrofoam head back, and there's definitely more volume there. Okay, so I'll just do this. I'll continue that flow, and you notice the gravity. Okay, so now let me dab that and add the blood source again. So based on the position, as her head rotates backwards to a point where gravity's effect, it has to be rotated a little bit back. And then now, this is what I want you to see. As her head then tilts more backwards, more up, that's what documents the position of the Sharpie pen on the styrofoam head to be in that position as the blood flow on Kendy's face. So it was a change of direction to allow first rotating and counterclockwise, but then her head had to flip way back for that stain to make that little turn to the right. And so we'll let this dry, and again it may flake off, but that's the position which would then be consistent with the evidence on her face.
All right, thank you. I just have a few more questions for you. You could probably retake your seat while we let those things dry. Okay, Mr. Beasley, taking into account what we just saw here with this particular exhibit and the crime scene photos, specifically the bathtub and where the bathtub was in relationship to her head, you base your opinion that she had to be moved on the location of the bathtub and where her head was, as well as this particular exhibit.
Yes.
Can you describe that for us, please?
How the body was moved.
Yeah, when you take into account that she had a bathtub behind her head and the blood is flowing upwards out of her mouth.
So for her body to be moved like that in such a way where the stains on her right breast were not disturbed, the best explanation would be in a way like picking her up by her arms to move her body up more in a position against the wall of the tub. And so her position of being picked up that way would allow her head to flop backwards.
Objection, Your Honor. May we approach?
You may. You may be seated. Objections, counsel?
Your Honor, Foundation, if I can explain, we have a list of what Mr. Beasley was provided. He was provided 2 photos from Officer Wheeler. That was taken roughly an hour or so after the 911 call. He was provided 5 photos from Northrop, which is what the basis of this opinion is on, which was 8 hours later when the tub has drained. And then he provided 5 photos from the coroner that was taken as they were draining the water to remove the body. There has been no demonstration of the photos from Mr. Wheeler at the time that law enforcement arrived, from Deputy Wheeler, from the time law enforcement arrived, and explain the differences in water level and how that impact, which also shows, especially in Wheeler's photos, the interjection of the hair. To take photos as they're draining the tub and put them on and use an opinion to say this shows she must have been carried in this sort of way, there's not been foundation for that, and it's highly speculative and it should not be allowed without the proper foundation on what he relied on and comparing the photos from Wheeler to the coroner's photos.
Response?
Well, it seemed to me the objection was that her head flopped back. It wasn't based on anything that preceded that. What preceded that appeared to me to lay the foundation for the opinion that her head dropped. That was admitting photographs that have already been admitted in this photograph that simply had flow channels on them on her face, and then using those photographs and the head exhibit to show how her head would have flopped in order to create that flow pattern. So when the objection here is to lack of foundation, and the foundation appears to have been put in front of the jury by means of photographs that have already been admitted, and then by showing a demonstration, it would appear to me to be unfounded. I think it's entirely reasonable for this witness to reach a conclusion that her head flopped when he had to do the same in front of the jury with that styrofoam head. And so I think the foundation was laid, and I think the court should overrule the objection.
Excuse me. Mr. Johnson, anything further?
Yes, to touch on that, certainly this will come up later, but there's going to be force applied to a gunshot, and there's going to be head movement, presumably possibly even striking the back of the tub. The body's going to change positions. Additionally, there's gravity that's coming down from the water. The hair that in the coroner's photos is not seen because as the water's going down, so is the hair. And so, again, I plan to deal with this cross, but when you start soliciting an opinion that it must have been lifted or moved based upon the coroner's photos taken 8 hours later as the tub was drained and the body's being removed, there's not enough foundation to solicit an opinion at this point that she was lifted up in a particular manner. Certainly, he testified that it might have moved, and I was going to cross him on that, and I will cross him on that. But that's different than an opinion that she must have been lifted up based upon these photos.
All right. Well, in terms of what he was testifying to, he was answering that for her body to be moved. How would her body need to be moved to provide for that blood, that directional flow of her blood, or for those blood stains to appear the way they did? In terms of hearing his testimony, he's certainly provided foundation as an expert on blood stain pattern, flow patterns of blood, and he's demonstrated it for the jury. And the question, as I understood it, was then how would that body need to be moved in order to then account for the blood stain pattern, directional flow that he observed on the victim? And he was describing what, in his view, is probably the most likely or best explanation for how she would have been moved. That's foundationally, I find that he has established the foundation for his opinion and why. The objection raised is certainly fodder for cross-examination. Certainly well within the defense's rights. The question about, I didn't understand his opinion to be, this is precisely what happened to Ms. Howard. Rather, his opinion being, in viewing the blood directional flow, this is a explanation, in his opinion, he said best explanation for how you would move that body to accomplish this. I think foundation is sufficient for that. And so I'm going to overrule the objection. And again, noting that you're more than welcome to cross-examine him on all the defects you think in his analysis. But as his analysis and his opinion at this point, I find there's sufficient foundation.
Can we then ask that when he gives opinion that it is hypothetical, not as applied to Ms. Howard? Unless you're proper.
I'm not going to tell him how to testify. I think his opinion to this point has been supported by sufficient foundation. So I'm allowing his testimony at this point. If you think it goes beyond that, you're always welcome to object again. All right, let's go to the jury now. Can you see it? All right, I have overruled the objection. You may continue.
Okay, so Mr. Beasley, you were talking about 55J and the explanation as to how blood could have gone up her face as opposed to down her face based on how she was found in the tub. Do you remember that?
Yes.
Is it your opinion or not that she had to be moved in order to create that blood directionality going up her face?
Absolutely, had to have been moved.
And would this have been after she began bleeding out of her mouth?
Yes.
Okay. Would her head have moved after she began bleeding out of her mouth in the direction that you showed us with 55J?
Not in the position that she was found. No.
But when she was moved, would her head have to have been flopped back like you showed us with 55J?
Yes.
Put in front of you what's been marked as Exhibit 87. Do you recognize that?
Yes.
What do you recognize that to be?
It's a copy of my curriculum that I, CV basically, resume.
Is it accurate?
Yes.
Move to admit 87.
No, Judge.
87 is admitted.
Call for the questions.
Your Honor, would you consider taking it's going to take me a few minutes to gather some exhibits and set up the Zoom. If we take our mid-morning a little early.
Okay, sure, we can do that. So we'll take our mid-morning break at this time. Yeah, I know you guys were just out, but we'll take a break for mid-morning and mid-lunch to discuss things. Thank you. Council, let's shoot for 10 to 15 minutes. Will that be sufficient?
15 should be fine.
We can recess. Please be seated. Cross-examination, Mr. Johnson.
Thank you, Your Honor. Morning, sir.
Good morning.
Now, it's important, working with a criminal investigation for so many years, it's important to pay attention to the details surrounding what you're observing, correct?
Yes.
Okay. Permission to approach Madam Clerk, Your Honor. Do you know what time Mr. Howard called 911?
I don't recall what time that would be.
Do you know what time law enforcement arrived?
I don't recall.
Do you recall how long it took him to arrive?
No.
Do you know how long it was before photos were first taken?
Exactly no.
Do you know who took those first photos?
I don't recall.
Do you know how long it was before other sets of photos were taken?
No.
Do you know how long it was between those photos and when they started to drain the tub to remove Ms. Howard?
No.
Do you know when the coroner took her photos?
I don't recall.
And when I refer to the coroner taking photos, I'm referring to the photos she took as Ms. Howard was being removed.
Correct.
Okay. Now, you would agree that some of what goes into blood flow is the consistency of the blood, or the clotting level of blood, correct?
Correct.
And that's an individual aspect, correct?
Individual aspect?
Meaning different people can clot at different levels, correct?
Correct.
Now, are you aware that once 911 was called, Mr. Howard was on the phone with them until law enforcement arrived?
I do not know that.
Okay. So, is it your opinion that the head would have had to been moved prior to calling 911?
No, my opinion is the body was moved after there was blood present on her breast and her nose and her mouth.
Do you know whether Mr. Howard checked Ms. Howard for a pulse? Do
I don't know if he did that, no. I think he stated that he did, but that's all I know.
you know if law enforcement checked Ms. Howard for a pulse?
I do not.
Now, there are a lot of pictures in this case, but you were only provided 15 photos, correct?
No, I was provided more than that.
Let me rephrase. You testified previously at a hearing in this matter, correct?
Yes, a grand jury.
At that time of your testimony, you were provided 15 photos, correct?
I don't think that that's the case. As I recall, I was provided some initial photos, but then was given all of the crime scene photos and all of the autopsy photos. I may have referenced a few photos prior to the grand jury hearing or during what I was going to be testifying about.
May we approach, Your Honor?
You may.
Defense requested knowledge of what was provided. Did you assist in helping the state fill out any of those documents?
I'm going to object to counsel's first statement because it wasn't a question, it was a statement from counsel.
I'll rephrase. Did you assist in having the state respond to any discovery?
How do you mean assist?
Withdrawn. I'm going to show you what's been marked as 17A. And I apologize in advance, Mr. Beasley. There is a little bit of a lag in the photos or in the Zoom connection. You see this photo?
Yes.
Do you know when this is taken?
Not specifically, prior to her being removed from the tub, of course.
And when we look, I think we have another image that we'll examine earlier, but when we look into this area and this area, there's dark pools of blood, correct?
Yes, there's areas you're referencing above her right shoulder and then near her face, her mouth.
Okay. I'm showing you what's been marked as 17D. You see that photo?
Yes.
You see, again, you see the dark pools of blood and or hair right here?
Yes, a darker area of more concentrated blood, I would say, in the water itself.
Okay. Now, is it true that in analyzing blood flow, objects can impact the directionality, correct?
Well, blood flow and directionality, as far as objects affecting that, how do you mean?
Meaning, if there's an object preventing gravity from going down, it's going to move a different direction, correct?
If there's an object that could interrupt the flow of blood, yes.
I'm going to come back to this one in a minute. I'm showing you what's been marked as 62D. You see that photo?
Yes.
You see that line around the leg?
The line on her left thigh, it appears to be where the water receded from.
Is that about the same distance as that line? Again, sorry about the leg. Seem to be about the same distance?
Yes.
Okay.
You're talking about the line on her chest.
I'm also talking about the line between the water and the blood line.
Okay, so the line on the flow pattern from the corner of her right side of her mouth up to where the flow pattern stopped.
Yes.
Yes.
It's consistent with the line on the leg, correct?
Yes.
Okay. Again, I'm showing you what's been marked as 62E. Is this where you see the pool of blood kind of coagulating down towards the bottom? Right here?
I would describe it as a higher concentration of blood, not a pool per se.
Okay. And then I'm showing you what's been marked as admitted as 62F. You see that photo?
Yes.
Now, move it over. You see this line of hair that comes down right here and intersects your bloodline?
Not clearly, no. I don't see the hair that you're referring to.
Okay. May I approach one?
Yeah. Okay. You want me to answer that question there?
I'll ask it here in a second.
Sorry, I should note, just as a direct, if you need to step out in order to view the exhibit better, feel free to do that if you need to.
So, looking at going from the eyebrow, right here, I'm going to draw to the, let me make sure I got all my lines off. Okay. I'm going to draw to the right side of it. See this hair coming down here?
Yes, I think let me go ahead and.
My question right now is if you see it. But yeah.
I do see the hair. It's
Okay.
referencing kind of close to her right eye.
And if we go zoom closer, see how that hair intersects the bloodline?
I don't see, I wouldn't confirm that it intersects from that position, that photograph. It may be in a direct line, but yet if from a different position, it would be better to determine if the hair actually in contact with the blood flow or not.
The hair will darken if exposed to blood, correct?
The hair would be more a blood red color, yes, if it's in contact.
Okay. Now, again, this is a photo taken early on by law enforcement. Do you see this photo?
I do, and that's what is exhibit.
This is exhibit 16G.
I see that.
Okay. And at this photo, the bubbles are still in the water.
Yep.
Okay. And her head is slumped over to the water towards the right.
Her head is tilted to the right.
Yes. As that water drains, that hair is not going to stay in midair, correct?
Objection, lack of foundation as to what hair was in midair.
If you can be specific what you're referring to, I'll stay in the judgment.
Just in general, if you put hair over, if your hair is resting on the water, I notice we don't have a wig on here, but if we imagine,
Counsel's testimony yet again.
I'll drop. If we put a wig on this demonstration, or have a lady with hair in the water and it's floating, as that water goes, is the hair going to go down?
The hair may go down, and that would be separate from the blood flow pattern on her face.
So if hair is affecting directionality or any sort of direction, it would be important to know when those photos were taken, why they were taken, what the body position was taken, where the hair position was taken before making an analysis, correct?
Objection, that is a compound question.
Sustain us to the form of the question.
It would be important to know when the photos were taken, correct?
That would depend on how that would affect my opinion, knowing when the photos were taken.
It'd be important to know where the hair was at the time those photos were taken, correct?
only if the hair would be involved in somehow changing the flow pattern, which in this case, in my opinion, there's no evidence to show that. The hair was involved in somehow altering or misdirecting the blood flow from her mouth or her nose or her right breast.
So you said you would provide all the materials, or a lot of materials in this case, correct?
Correct.
There's no blood stains found anywhere else in the house, correct?
I'm not aware of that.
There's no blood found on Mr. Howard, correct?
I'm not aware if there was or not.
Okay. There's no, other than this flow pattern, there's no physical evidence of a body being moved, correct?
Well, actually, there's evidence of 3 different flow patterns, and they're all consistent. So the stain on her breast, her right breast, on the nipple, and then 2 separate flow patterns from her left nostril and from the corner of her right mouth, the side of her mouth. So there's 3 flow patterns, not 1. They're consistent with her body being moved in this case.
So let's talk about that. Do you know how much blood would be ejected from the mouth with an injury such as was sustained by Ms. Howard?
Objection beyond the scope of correct.
Goes to his hard conclusion, Your Honor.
Overrule if he does.
There would be no way to know how much blood. Are you talking about blood spatter or flowing
Yes.
blood?
Well, either one. Blood spatter?
So that depends on the circumstances of the case.
Okay.
So in this case, there were signs of what appeared to be back spatter, little specks of blood on her chest, on her body, that would be consistent with a gunshot wound with her mouth in an open position to allow blood to be spattered backward.
And is it your opinion that Mr. Howard's DNA was found on that gun?
Objection to lack of foundation beyond the scope of correct.
Sustained.
Do you know whether blood spatter was found on the gun?
Same 2 objections.
Goes to blood spatter.
It's sustained, there's no foundation.
Are you aware of any blood spatter on the left wrist or left hand?
There's possible blood spatter on her left hand.
And any blood spatter on the right hand?
The hand was in the water. I do not believe that there was any spatter on her right hand.
If a person sustains a gunshot intraorally, can that cause any sort of head or body movement?
The gunshot itself,
Yes.
some movement, yes.
So
It would be minimal, put it that way.
if Mr. Howard shot her, did he shoot her before filling up the tub or afterwards?
Same 2 objections. There's lack of foundation for that question. It's beyond the scope of correct.
Sustained on the first grounds, certainly no foundation.
May we approach?
Sure.
I'll rephrase. Do you know if the body, your opinion is the body was moved, do you know if it was moved before water was put in the tub?
No.
Do you know if water was put in after the tub was filled?
I don't know when the tub was filled.
You don't have any evidence of well, let me strike that. So you don't have an opinion as far as when it was moved?
It being,
The head?
okay. Well, my opinion would be that the head was moved in a position as demonstrated with the styrofoam head after blood was present in her nose and mouth.
Do you have here with you the ability to model the same thing with a wig in a tub?
So as far as the
Modeling for the jury?
it wouldn't change the flow pattern if I had a wig on the styrofoam head.
I have no further questions. Permission
If
to.
you, I'm sorry, you can approach. Is it that? Redirect.
Thank you, Judge. Counsel asked us some questions about what you took a look at in order to get ready for this case. Were you asked essentially the same thing at grand jury?
Yes.
And did you respond in essentially the same fashion that you did here today?
I think I was a little more specific in the grand jury, but basically,
Well, let me show you page 808 of the grand jury transcript, beginning with line 18 and going over to page 809, line 1, okay?
okay. Okay.
You remember what right when first did you take the case?
Yes, so it was police reports, crime scene photographs, autopsy photographs, basically everything related to the incident specific to her in the bathtub.
Okay. Essentially the same thing she testified to on director today?
Yes.
You weren't just given a limited number of photographs then, were you?
No, I always ask for all of the photos that they have.
Okay, so if this Sergeant from Head were wearing a wig, why wouldn't it change the direction of the flow pattern coming from her nose and mouth?
Because, I mean, it could affect the flow pattern, but as the actual evidence, I didn't see anything with her hair. Her hair had a lot, and I looked, a lot of brown highlights and other highlights in her hair. I did not see hair in stuck or in a position to affect the flow pattern at all. What I saw was the dilution of a flow pattern that flowed from her mouth along to her right cheek that then was partially diluted from the water level, but yet the water level did not totally cover the very end of that flow pattern, either flow pattern.
Counsel asked you a question about whether or not the gunshot itself would contribute to a change in blow pattern. What's your opinion on that?
No, absolutely would not change it at all. The gunshot wound was in her mouth, and so the blood flow is from gravity after she was shot. Would not have an effect, any muscle gases related from the gunshot.
In speaking with counsel, you and he discussed why there was not one or just two, but three different distinct flow patterns that were all consistent with each other in terms of her body being moved. Can you elaborate on that, please?
Yes, so the position that she was found is such that those flow patterns are all consistent with her body being significantly moved, lifted from that position, let's say, so that her head would flop backward for gravity to create those flow patterns. And so any other manipulation or checking pulse or whatever of the body would not do that unless her body was lifted up.
Thank you. No further questions.
Thank you, sir. You may step down, and if you want to retrieve your things other than the head and the two, the paper and the styrofoam, I think those are demonstrative exhibits. You have to label as such, is that right?
Yes, would you like me to leave them there or lodge them at the railing by your clerk?
Why don't you lodge them with the clerk?
Okay, I can put this all the way now.
Sure.
Just got one little cleanup thing to do here.
Thank you, sir.
Thank you.
Next witness.
Philip Hanger is our last witness.
Morning, sir. Could you please approach my clerk and raise your right hand, please.
You solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God.
Thank you, sir. You have a seat with the stand. And as best you can, if you would speak in the microphone. This is our today's hearing. You may depart.
Thank you, Judge. Sir, can you state your full name and spell your last?
Philip Hanger, Philip,
How are you employed?
I'm self-employed as a clinical psychologist licensed in the state of Idaho.
Can you walk us through your educational background?
I have a doctorate, a PhD from the University of Florida. I obtained in 1989. Along the way, received a master's also from the University of Florida. Before that, undergraduate in psychology from the University of Iowa.
Can you walk us through your career up to now in Coeur d'Alene, beginning back when you started off?
Sure. I've been practicing as a psychologist for approximately 30 years. The first third of my career specializing in neuropsychology, working in rehabilitation hospitals, providing assessments of individuals who suffered from brain injury, going through recovery. The second third, essentially, of my career, I was working in San Diego, California, where I was the Assistant Deputy Director of Forensic Mental Health Services. I oversaw the adult and juvenile forensic services for the services provided by the mental health in San Diego, as well as doing assessments for their court system. The last approximately 10 years, I have worked up here in northern Idaho, providing services as a forensics expert, providing assessments for the courts in the northern region of Idaho, as well as evaluations for the hospitals.
Let me approach you with 79.
a copy of my vita, my resume. Yes.
We look at 79.
No objection.
79 is admitted.
Okay, so working up here in Idaho for the last 10 years, have you become a designated examiner?
Yes, in approximately 2015, I was appointed by the state of Idaho as a senior designated examiner. That position is to perform independent evaluations for individuals who are under involuntary mental health hold, either in the hospitals or the courts, providing a probabilistic determination, a estimate of imminent risk of harm to self or ability to care for self, and whether or not that hold needs to be continued.
How often have you done that?
In the past 10 years, over 1,200, so about well over 100 a year.
And so essentially what you're doing is determining the likelihood of whether or not someone's going to sometimes commit suicide. Is that accurate?
That includes it's a danger to harming self, harming others, or grave disability, inability to take care of themselves because of a mental health condition. And it is through the process of being directed by the court, essentially being asked under court order to complete the senior designated exam to determine whether or not there is still a risk.
Is there a process you follow?
Yes, it is a process of available records, so reviewing records from either previous hospitalizations, current hospitalizations, talking with staff, talking with family when I can, and then a direct examination of the patient.
Can you indicate to us what a forensic mental health record review is?
Well, depending on the question, sometimes I'm performing evaluations that are for the court in criminal matters, and sometimes in civil matters, a commitment hearing or an involuntary commitment. So it's looking for indications of a mental health condition, cognitive impairment, serious mental illness, such as something that might be diagnosed, or a set of symptoms that might not have been diagnosed yet, but shows an indication of significant distress. Looking at the risk factors that increase the likelihood, the probability of an individual based on history, whether or not they're going to harm themselves or be unable to take care of themselves. And looking at what's called mitigating factors, because an individual may have certain risk factors, but they're coping, they're adjusting. Mitigating factors, how does that lessen the likelihood? And then from that, making a clinical determination, as a senior designated examiner, based on my 30 years experience, putting all that together to determine what is the risk. Is it at a level of risk that there might be imminent harm?
Did you put together a PowerPoint that kind of illustrates those points?
Yes, I did.
And does it put into focus the various risks that go along with making this assessment, as well as any mitigating factors?
Yes, the PowerPoint is an outline of the increasing risk factors, those factors that might be indicators that there might be a greater likelihood than not of a person harming themselves, and the mitigating factors, those that I would look for in a person's history, their life, that might stave off, decrease their likelihood.
Okay, I have it March 52. Take a look at it. Tell me if you recognize it.
Yes, I reviewed this earlier. My initials on the date.
What do you recognize? 52?
52 had a copy of my PowerPoint presentation on it.
And that would help your testimony here.
Yes, absolutely.
Would you make 52?
For demonstrative purposes, no objection.
I'll be admitted as a demonstrative individual.
Move to publish the same.
You here?
Dr. Hager, if you need to step around to see more clearly, you're welcome to do so. You can see from there, you're fine.
You need a pointer?
Clicker, go ahead, thanks.
Okay, so Dr. Hanger, we're looking at a screen here. It's entitled on the left side, suicide, self-harm, and on the left it's got increased risk, on the right, decreased risk. Can you explain your thoughts on this in terms of your assessment about risks of self-inflicted harm as well as decreased risks of the same?
So when considering either in a situation where I'm examining a patient directly for risk, and in this case risk of self-harm, or posthumously after the fact reviewing records to determine if a person had exhibited a risk, I'll look at those that increase, those factors which may contribute, may be causally, to be correlated, not necessarily causally, these are increased factors, and then the decreased risk factors or mitigating factors.
All right, so go ahead, please.
Under the factors that increase risk, the presence of a mental health and mental illness, and this is one of the highest correlates with self-harm, suicide. These are generally diagnoses that exist in the patient's record: depression, a mood instability, bipolar disorder. It could be indications of a reactive response, a post-traumatic stress disorder, then lower risk, so it's going down in gradient of risk. The psychosis, schizophrenia, more likely to have problems in self-care, great disability than suicide, and then personality disorders. So some personality styles that are maladaptive, the individual may not be able to regulate their emotions and behavior. So looking at the presence of mental illness, a diagnosis in a record from family reports, looking at mental illness in terms of maybe it's undiagnosed and merely the presentation of symptoms that I as a professional would say that appears to be psychological stress or indications of a mental illness. So
Are there increased risks?
next one. The next factor is substance abuse, and this has two factors. One is the acute or intoxication that very often an individual may, because of the disinhibition of substance use, alcohol, methamphetamine, not be able to regulate. Quite often interviewing individuals who have made a gesture and attempt that when they sober, when they abstain from use, they no longer are extremely agitated or having a risk for harming themselves. So looking for, are they intoxicated? What's the toxicology screen show for an individual? Do they have a level of intoxication that might mean that they cannot regulate? Also at risk are individuals who have had a chronic history of abuse, individuals who for a long time have been told this is a problem, this is something that needs to be addressed, and now they're beginning to abstain, they're going through withdrawals, heroin withdrawals, alcohol, methamphetamine, and that it's after a prolonged use that has caused problems that now they are decreasing, and there can be an increased risk of agitation, and that can lead to increased risk of suicide.
Can a family history also increase risk?
In terms of asking about family history, this is the indicator that an individual may have a genetic marker for a mental illness or increased susceptibility for substance use. So in the family, has there been a mental health condition which makes them more at risk for the development or the development of mental illness? Same thing with substance use. Is there a pattern of substance use in the home, in the family, that indicates that this individual may be more at risk? The next factor is proximal factors. These are a large category and much broader focus on the individual's stressors, their life stressors. What are the crisis, immediate stressors that the person is experiencing, or the chronic, long-term stressors? We all have stressors, so it's not a matter of discovering are there any stressors, it's which ones. So there may be various ways that we're asking my family, looking at records, and doing a tabulation of what is this individual experiencing in terms of stressors. And of course, stressors don't mean a risk of suicide, they just mean a person may have to adapt, cope, to have a functional lifestyle, to be able to continue living. So an individual who has significant stressors but is still functioning in the community, that's because they have adaptive factors, which we'll also look at when we get to the decreased risk. Those factors which show that they're coping, how do they adjust, how are they dealing with the stressors? So a person who has effective, high level of coping, they're going to continue to function in the community. Those who are having a lower level of adaptive functioning can't respond to the stressors, and they show signs that others will begin to see are stress-related, not functioning difficulties. The extreme, an individual who has high stressors but doesn't have a perception of any adaptive, that they're trapped, there's no way out, those are individuals who may be more likely to be at significant risk of suicide. So I'm looking at the proximal factors, the life stressors, and it also can include the environment. Where are they in terms of access to weapons? Is there a handgun? Is there medication? Are they on a medication, a painkiller that might increase their risk? But again, that's not an indication of suicide itself. Then how are they adapting to that? How do they cope with those factors? Lastly is the distal factors. These are the stable, age, gender. Men are more likely to commit suicide. Non-Hispanic white, more likely to commit suicide. These are less often an indicator that I take into consideration in weighing, but it may give an indication in terms of how likely, or giving some kind of a question to, is this a population that might be more at risk? These are not changeable, whereas the adaptive, the coping to the proximal factors, your stress, that is changeable. That is how somebody can take control of their life. That is how friends and family can do something to help them. That's how mental health professionals address the suicide risk. How are you coping with these? The distal factors, your age, not so much, but it may be an indication of, well, as a person's getting older, increased risk of suicide in terms of the probability, the statistical probability, then that might be something that family begin to look for or to look at in that population. So, as I mentioned, that the coping abilities, those are what decrease the risk factors. The strongest is social contact. How involved, how connected a person is. Do they maintain regular contact with family, with friends? How engaged are they? How open are they to express themselves? The expression often heard is that, well, it came out of the blue. We didn't expect this self-harm or suicide comes from, and that's an indication that there was diminished contact. They socially isolated, they pulled back. So you didn't hear from them, or that person was not expressing themselves. So yeah, it was something that came out of the blue. But that, again, is an indication that as the person is decreasing expressing themselves, family, friends can step in. Hey, let's talk, let's visit with you. Or if the person is open and is open book, then it certainly is not going to be a concern that this is a person who family, friends can read this person, they're in regular contact, it diminishes the risk of their having difficulty coping with those life stressors. The next is a significant category. We look at their future focus, their hopefulness. How much are they able to look to the future, plan for the future? Are they still seeing there's a possibility? Are they seeing the light at the end of the tunnel? As opposed to feeling that they're trapped, there's no option, that the only option is self-harm. So someone who is telling me that here's my plans for the future, immediate, few days, few weeks, long term, here's what I'd like to do next year. Somebody who is expressing their future focus in positive terms. I'm looking forward to, I have plans, this is what I want to do. That decreases the risk of the weight of how much do these increased factors give me concern that this individual might commit suicide. They're hopeful. They're seeing that there might be still some options, that they have things to look forward to. They have plans, and they've made plans. The next is similar to social contact. That's their community engagement. So in isolation, a person may still take phone calls, may still be reaching out. Community engagement is a person's involvement, as it says, in the community. They're still traveling to work, they're still going shopping, they're still leaving the house, they're not secluding themselves. So a person who is still going about that, functioning in the community successfully, they're coping with the stressors. So they've got significant stressors, but they get out in the community and they continue to meet their needs, which demonstrates they are adjusting, they are coping with those stressors. The last question, or the last focus, is on self-care. An individual who is at greater risk for harm is one who decreases their focus on their self-care. May not be bathing, grooming, may not care how they look. They're isolating, they're withdrawn from the community, they're not hopeful, and you can see the physical signs in terms of their grooming, in terms of their interest in grooming and future grooming activities.
Are there imminent risks of suicide or self-harm?
Well, we generally look at the likelihood of self-harm as being increased when a person is in acute distress. Depression, most common, but it can be other forms of agitation, extreme distress. The individuals who are at imminent risk, meaning without intervention, without us maintaining an involuntary hold, they are likely to commit suicide. So this is one of the significant red flags or the concerns that I would have if somebody presents with an acute depression or a significant acute serious mental illness. The next is of course, there have to be stressors. There is always factors which push the person over, unless it's extreme intoxication, but even then there can be some indication, some factor that the person perceived. But there are stressors. It's not a completely undetectable. Oftentimes it is, moving forward, difficult to see through what is the person experiencing, but looking for what are the major factors, major stressors in their lives, those we can then begin to add up and look for. What is the reason, what is the difficulty this person is having in adjusting that led them to say, I'm trapped, there's nowhere out, I cannot go. Most significant is hopefulness, that future focus. When a person has attempted suicide, I have the opportunity oftentimes to interview them afterwards, and it's a misunderstanding to say that completed suicide is different from attempted suicide. It's really a distinction of those who are talking, contemplating it, versus those who take action. So if you take action, if you attempt suicide, you expect it, and quite often when I'm interviewing these people who have attempted but did not complete an incomplete suicide, they still give that expression of, I did that because I felt there was no other option. I was trapped, I had no hopes, no plans, I couldn't see this was the best option. So we as psychologists quite often get to talk to individuals that have had that level of distress where they literally have seen individuals who shot themselves and then survived, hanging, poisoned, overdoses, and they expected, as I'm interviewing afterwards, I wasn't expecting I would be alive, and now I can tell you what led to that. Let's go through the major stressors. I can talk with family members, what are the major stressors. Let's examine how hopeful they were. What were they planning? What were they looking forward to? And again, helping to direct so that the families of the individual can overcome, so they can build up this coping, this adjustment capacity, so that they don't feel that they're unable to face these life stressors. There's not always a suicide note, there's not always an expression, but that certainly is a significant red flag. The person who has planned, who has access to, maybe they've got medication, they have talked about, well, if I was going to do it, here's what I would do, or literally have gone out and purchased some lethal device that might likely end their life. So having that targeted, specific plan, that's something that I'm looking for as well. The social withdrawal. Significant adjustment to stressors are the therapeutic benefit of being with people, being in communication with people, continuing to engage with individuals. The population that I see that are at elevated risk for suicide are those that have pulled back. They don't have, unfortunately, sometimes family or friends that are in the area. That increases the risk. That's some of the questions that I have for them or looking through the records. If they return to the community, leaving the hospital, who else is going to be in their lives? And lastly, substance abuse. Quite often we use a toxicology screen to determine is this an individual who has substance use that is going to increase their risk by disinhibition, or is this somebody who, in the record, or by family report, or the history that I've seen this person, and they do struggle with substance use, methamphetamine use, continual alcohol use to causing problems in their lives.
So in making these assessments, can you do it with a person who's deceased?
Yes.
All right. And in terms of a person that's deceased as well as someone that's alive, either way, are you relying on a particular process?
The process I described, with the obvious exclusion of being unable to do a direct examination of the decedent, I will rely on the medical records that are available, the family members, the friends that give testimony in the hospital, On many occasions when I was working in rehabilitation facilities, an individual who then subsequently succumbed to their injuries, their self-harm, talking with family members and unable to examine them other than their history, other than their medical history that we have documented from before they came in injured, and their family members, being able to review that and looking for, here are the factors, here's what helps explain the families that they may have missed in their leading up to, here's what they could in terms of explaining why is this person at higher risk and why did they do this.
And I take it by using these factors, you can reach opinions and conclusions?
Yes, I can. In fact, I'm called on, as I mentioned before, 100 times a year by the state of Idaho, directed under court order to do this determination. This individual, how likely are they? Are they at imminent risk for harming themselves, others, or being unable to take care of themselves?
Using medical records, talking to family, talking to friends, are all these things experts in your field rely upon in order to reach these types of opinions?
Yes, they are, as well as direct examination when available.
So, in this particular case, what did you look at in order to come to a conclusion or opinion about Kendy Howard?
I was provided a significant number of records for review that included, let me just read them slowly for you. The pharmacy records from Ms. Howard, a police report, agency assist record, a crime lab report, the transcript of interviews post-event with Wyatt Howard, son, Michelle Lambert, a friend, Kim Mock, friend, Dan Prado, friend, a prescription optometric eyeglasses prescription, police report and a welfare check earlier in that year, a police report and supplemental reports from the incident events, Ms. Howard's post-falls family medicine records, coroner report, autopsy reports, a significant number of Facebook messaging dialogues between Ms. Howard and several friends and family, Zach Goodwin, Wyatt Howard, Kendall Wilkins, Tana Myers, Roy Fitting, Michelle Lambert, Mark Santo, Jill Bacala, Janie Nichols, Dan Prado, Dan Howard, Courtney Lambert, Chris Sapansky, Chantel Souther, Carly Maitland, Brooke Wilkins, Brian Wilkins. I also had the opportunity to look at several folders with evidence photos, crime scene photos, the evidence photos that were also obtained from items photographed in the home.
Okay, so backing up to her medical records or prescription records, could you draw any conclusions there?
With the first risk factor, I was looking for presence of mental illness. And with the exception of a reference in April of 2019 when Ms. Howard expressed to her treating professional that she had some distress about a medical condition, at that point it was recommended that she could consider being on anti-anxiety medication, which she subsequently declined. 3 months later, in July, those records indicate that she had resolved that anxiety, and subsequent records using both her statements of her mood as well as her responses to some screening questions, the patient health questionnaire, which asks directly, are you having feelings of distress or significant emotional discomfort, depression? Are you feeling hopeless? Do you have plans for the future? Those consistently in her records show that there was no indication of the serious level, a serious mental illness that would be identified with a diagnosis. Also didn't show a consistent pattern of significant emotional distress that would cause concern that this is a person who's undiagnosed with a mental health condition.
And so that incident in 2019 where she had some anxiety, that was due to a scare over possible breast cancer? Does that sound correct?
That's correct, yes.
Okay. What about her prescription medication history? Anything about that you could draw any conclusions from?
The photographic evidence indicated that there were a number of historic prescriptions that Ms. Howard had been given that included antibiotics. The most recent consistent ones that she also had not been taking consistently, so consistent in terms of their more recent to the date of her death, were a medication that's colloquially labeled as an antidepressant, Prozac, and it is commonly prescribed for eating disorders. So specifically on the label, it indicated that her doc, Dr. Miller, I believe, prescribed it for compulsive eating. That's a common use for that medication. So it wasn't by nature of the label, the type of medication for depression. It was a approved use for diminishing compulsive eating. She was also prescribed a medication, Phentergan, which is a stimulant, which decreases appetite. And those two medications she was most consistently on, but again, not consistently. At the point of autopsy, the toxicology screen shows that there was no presence of either of those in her system. The review, the pill counting they did and photographed indicated that she had a number of her prescriptions that she had not been maintaining and taking. So there's a risk with those two medications. There's what's called a black box warning. They can increase suicide risk. Prozac and Phentergan can or have been found to increase suicide risk, but that's in the presence of a mental illness. And so when prescribing these medications, it's common practice for the prescribing professional to do a significant screen, continual screen. Is there mental illness? So that again supports the first issue that I was looking for. The first factor is that if this individual had a mental health risk, had the presence of significant depression, and the prescribing professional was using that medication for something other than treating the depression, it would have been inappropriately prescribed. So having that evidence that this is a person who did not have an underlying mental health condition, those two medications which activate, stimulate, wouldn't be increasing that level of despair, suicidality. It's not that these medications cause suicide, they increase activation. So an individual with an underlying mental illness with a predisposition for self-harm, now as they become more activated, that's why these medications will cause an increased risk of self-harm.
What about interviews with family and friends? Anything about that caused you some sort of concerns or issues in terms of increased risks of suicide or self-harm?
The interviews, with the exception of that offered by her husband, Dan Howard, did not provide an indication of concern for risk of self-harm. In fact, they described her as showing a bright, happy, excited, looking forward to the future. So her affect was in its general statements that they make in their interviews, as well as in the Facebook messaging posts, indicating a indication that that Ms. Howard was exhibiting the continued positive affect, bright affect, not suffering from significant or even reactive despondence, with the exception of her interactions with her husband, where those Facebook posts reflect the distress of arguing, the reference from her husband that he felt that she had a mental health condition and should be seeking treatment for it. Otherwise, no family members, in fact, family members specifically said that they did not see a mental illness, were not concerned about that, did not see a negative affect, with the exception of her being apprehensive, scared about the divorce, about the separation, about having that expected apprehensive response after decades of marriage, where the individual is now facing life changes.
What about those components of substance abuse and family history? Did either of those raise their head in terms of concern for you here?
In the medical records, consistently, there was no report of any family that had developed mental illness or had shown signs of substance use. The substance use for Ms. Howard, she was described by friends as using alcohol. She consumed alcohol. That there was not a consistent report where there was significant concern that she was using alcohol or that they were addressing. The Facebook posting was oftentimes a continual back and forth where there was descriptions of upcoming social events. Let's get together for parties, for fishing, for social gatherings of vacationing, and no expression of concern about alcohol or any other drug use.
Proximal factors?
There were a moderate to high level of stressors in Ms. Howard's life. At the time of her death, she was going through divorce, which is a significant stressor, a significant life event that requires change. She was contemplating, not in the act of, but she was contemplating a change of job by her statements on Facebook posts and family friends acknowledging, yes, we were aware she was contemplating that. So an apprehensive stress, and stressors are positive and negative. A wedding is both. I mean, planning a wedding, getting married, having a new child is both positive and negative. So divorce can be positive and negative. Stressors are change, a change from routine. So anytime there's a change, that's stressful. We have to adapt to it. The temperature changes, we have to adapt to that. That's a stressor. So in her life, divorce, her anticipated change of job, her anticipated change of residence, buying a new house, looking forward to being in that new residence, again, a positive and negative. There's the hassles of moving, shopping. And lastly, the discord between her and her husband, so arguing with a spouse. So those four major categories represent significant stressors. And as I said before, it's not just that the stressors then cause suicide. How is the person adapting, coping? We could look at those mitigating factors, and in Ms. Howard's case, we look at the social contacts. She was maintaining regular contact with family. You look at the Facebook posts, and you see that a continual, almost simultaneous contact with friends and family, describing her interests, her focus, her lifestyle, what she's doing, interest in posts that are jovial jokes that she would exchange, as well as shopping ideas for her new house. So she was not isolating by that. So her coping, she was maintaining a significant connection. I would be less concerned about an individual who shows that level of family and friends are connected to this person, they're in this person's life, this person is sharing with these individuals as demonstrated in the Facebook posts. The next would be her future focus. That's another coping indicator. That person who significant stressors, divorce, arguing with the husband, but yet not seeing it as I'm trapped. Having here's my plan, here's my goal, she says in one of her Facebook posts. Here's what I plan to do in the future. Here's what I'm looking forward to. Yes, it's going to be stressful, but I've got hope, I've got a plan. This is how I'm going to get out of this, as opposed to I've got stressors and I'm trapped. I've got no option out. So now, maybe effective, maybe good or bad planning, but I've got a plan is always a significant indicator for me that this person is more likely than not to have that ability to overcome those stressors and continue to function. The next one is her community engagement. I saw in reference to Ms. Howard that she was continuing to go to work. She was continuing to go shopping, pick up cat food, went to the eye doctor, made appointments, kept her appointments with the house inspector that she was going through. So she's not disconnecting, but she's also not secluding herself into her home. She's out and engaged in the community. Again, a question that I would ask an individual on an interview. So what is What is in your future? What do you plan to do? What have you been doing? What is your day like? What's your daily routine? I go to work. I've got this appointment tomorrow. I've got these next few things. I've got an appointment for body augmentation. I'm looking forward to being able to have this change in my life, and here's how things are going to be different. Here's how I'm going to address the stressors. Self-care, looking at this is an individual who described she just had her nails done today. She's focusing on having her image. She struggled with her daughter acknowledges that, her friends acknowledge that she was always concerned about her weight, about her body image. Stressor, but she had a plan. She had an appointment for body sculpting, a consultation for breast augmentation, tummy tuck. She had a plan for moving forward. She had her nails done. She was looking at that, a positive image as opposed to someone who, I give up, I'm trapped, I have no choice, I have no options, what does it matter? And that increases the risk. So between her social contact, her future focus, she was hopeful, she was excited about the future, scared about the changes, normal response to stressors such as divorce, such as the issue of changing jobs. Those will be scary, they'll be apprehensive, but she wasn't stopping in terms of her planning, she was moving forward.
So ultimately, were you able to reach some conclusions after looking at these materials?
My impression from the collective of the records was that this is an individual who it's improbable that this person would be at risk, an imminent risk for self-harm. That this is not an individual who I would raise red flags to family members and suggest you've got somebody that needs additional intervention, needs more contact. She's at the maximum contact, maximum engagement. She was focusing on her future. This is not somebody who, in my impression, within a reasonable degree of psychological certainty, would be at imminent risk for suicide.
Thank you. No further questions.
Thank you. Cross-examination, Mr. Johnson.
Thank you, Your Honor. Good morning, Doctor.
Good morning.
Now, in your record review, did you make any phone calls to any of the individuals?
No.
So, for instance, the messages, I think there's, do you know how many pages of Facebook messages there were?
A great deal.
Okay. And when were you contacted by the state?
I was originally contacted, I believe, for January 2022 to review the records. Following that, in April 2023, I provided testimony to the grand jury.
Okay. Now, it's true that the bulk of your practice revolves around testifying for the court system?
That's right.
And you would agree that it is not possible to provide an absolute predictive determination of suicidality from a records review?
I believe that's a misleading question. The possibility is improved with more information. It is possible to give a probabilistic determination from the records. Adding more information increases the strength of that probability determination. So a record review can give an indication. It's not a desired closed system, but having that information from medical records, adding family records, ideally adding the decedent interview, but in this case not possible.
In a decedent or in a normal interview, when someone comes into your office, does an evaluation, you're relying on what they report to you, correct?
In fact, no, the difference between a forensic psychologist and a therapeutic psychologist, as a forensic psychologist, I'm looking at the truth, where the clinical psychologist doing treatment takes the patient where they are. The patient walks in saying that they have this history, saying they have this distress. The treating clinical psychologist follows that patient. As a forensic psychologist, I'm looking at trying to determine, I'm looking for inconsistencies, looking for patterns across. So it's not that I'm doubting, but I'm more skeptical. I am more interested in trying to find evidence to support or discredit that statement.
Let me just go a different direction here. There are tools that you can use as a forensic evaluator in psychology to help assess a person's risk, correct?
Yes.
One of those tools is a home and rule life stress inventory, correct?
Yes.
It considers such things as divorce, right?
That's correct.
Change to a different line of work,
Yes.
major change in a number of arguments with the spouse,
Yes.
major changes in living conditions.
Yes.
And you, in looking at that, the life stressors placed Ms. Howard above the threshold of 150, correct?
Yes. She had a moderate to high level of stressors in her life.
And at moderate to high degree of experiencing difficulty coping, correct?
Not necessarily. That is more often than not an individual with that high level of stressors. We would expect that they may have difficulty. A person may still be coping with a significant high level of stress, a chronic high level of stress. They're still coping. So it's not a scale of suicidality. It's not a scale of whether they're coping or not. It's a scale of what stressors, what changes are in their life. And now let's look at how are they coping? How are they by the outcome? They're functioning. How are they in terms of those mitigating factors? What are in place? What is she doing to address, deal with that high level of stress?
All right, Doctor, you filled out a report in this matter?
I'm sorry?
You filled out an opinion in this matter?
Yes, I have.
And I'd ask just so we can get through it. If I need an explanation, I'll ask you, and if counsel wants an explanation, we'll ask it. If you can just answer the questions, we'll try to move through this here. In your report, you indicated that above the threshold of 150, identified her as being a moderate high degree of experiencing difficulty coping, correct?
It puts her at that more likely than not risk category. It doesn't mean that she is experiencing.
And additionally, resulting in mental and or physical health challenges, correct?
As defined by stressors, meaning the requirement to adapt to deal with changes, that individual will be more actively applying those coping strategies. And the failure to do so may lead to emotional distress, but doesn't necessarily mean that they are experiencing emotional distress. They may find an effective coping strategy. They may have the ability to cope.
Maybe approach on.
Sure.
So, doctor, you indicated that you conducted that Holmes Rowe life stress inventory. Yes or no?
Objection asked and answered.
It's foundational for the next question.
Right, but you asked and that answered.
Yes.
I did.
Okay, so since you did that, there were indicators that then you took to adjust your assessment, correct?
Objection asked and answered already.
That was not asked.
Overruled.
The Holmes Ray is not a standardized instrument. It's a research instrument that is used to provide a recommended listing of stressors. From that recommended list, the clinician, myself, are at liberty to either add, augment, look at the circumstances of an individual's life, or include those in considering the questions that I may ask a patient or the records that I may look for. So it is a guideline. It's not a standardized, statistically a consistent measure. An individual who is going through divorce here is not experiencing the same stress level as an individual over here going through divorce. Whereas the scale provides a numeric value to give an indication. Let's give a ranking, a relative ranking, in terms of historic complaints of stressors related to divorce. But an individual's response to divorce may vary significantly based on their history, based on their emotional condition, based on their family support, all the mitigating factors. So it's not a hard and fast measure as much as a guideline.
COVID impacted depression rates, correct?
There are research studies that suggest there's a higher incident of mental disturbance, distress following COVID and during COVID.
The primary use of Prozac is to address depression, panic attacks, and compulsive disorders, correct?
That's a misappropriation of using the term primary. It is a list of uses which includes compulsive eating. So it was originally described as an antidepressant medication, but it has more recently been significantly prescribed for eating disorders, for individuals who want to control their weight.
Nurse Miller is a psychiatric nurse practitioner, correct?
I'm familiar that, yes, that's who she is.
The side effects of Prozac can be mental and mood changes, correct?
In some cases, yes.
And thoughts of suicide, correct?
Increase with underlying mental health condition. That's the research shows that that's the rule out is that in individuals who have an underlying mental health diagnosis, Prozac, with the absence of mental health condition, does not cause suicidal thoughts.
You're aware of Miss Howard being excited about getting her guns, correct?
No, I was not aware that she was, quote, excited. I was aware that she had been provided, that she had shared with family friends that she had been given a handgun that had been kept in storage because she did not want to. She was not, as daughter and friend described her, not a gun person. So I wouldn't qualify as excited.
And these interviews that you relied on were conducted fairly early on in the investigation, correct?
Prior to January 2022.
It is difficult for family members to accept the thought that someone would take their own life, correct?
Objection not the foundation. Beyond scope of merit.
I'm assuming you can answer that.
Can you repeat the question, please?
It is difficult sometimes for family members to accept the possibility that a loved one committed suicide, correct?
Yes.
Substance abuse, you talked about that trying to refrain from the use of a substance can increase risk, correct?
Not quite. Refraining from chronic problematic use causes distress. An individual who's a social drinker who has use of alcohol that has not been diagnosed as a chronic problem, then refraining from alcohol use would not be a significant increase in risk.
You said that prior ideations of suicide, either planned or attempted, is an imminent risk, correct?
Immediately prior. Historically is significant. An individual who maybe a year, 2 years, 3 years has made that statement, but it's the imminent, the individual who has presented at the hospital or who family are aware, they're talking of suicide. They've mentioned that they're feeling hopeless, trapped, no way out. That imminent ideation is the concern.
You referred to a one possible attempt that, or ideation, that you were made aware of through the records, correct?
Objection by foundation.
Was that on the record?
And beyond the scope of the record.
He specifically referred to it.
When did he specifically?
May we approach?
Yes, just a few minutes early for lunch, so I can discuss this in more detail with things. See you guys. You can see it. The question was that there was a lack of foundation in the scope of the record. You said it was asked on the record, and that he specifically referred to it. What are you referring to, Mr. Johnson?
Dr. Hanger specifically made reference, and I think the exact words are, other than a one attempt referred to by her husband or Mr. Howard, I don't know which one he said, I did not find any other evidence. So he specifically referred to that. I want to ask him questions about that. So it is within the scope of direct and fair to cross on.
Mr. Herring, your objection?
I don't recall that coming into the record, Judge. And more specifically, the idea of approaching every time that Mr. Johnson has an objection. I've never experienced that particular way of handling objections. I think in this case, if there's going to be objections, they should be lodged with the court at the time they're going to be made, rather than approach and talk about it in whispers in front of the jury. The more appropriate approach is for the court to make and ascertain whether or not that objection needs to be held outside the presence. And that we should do away with every time that Mr. Johnson wants to lodge an objection, that we have a huddle with the court and we talk it over. I don't think that's the proper way to proceed with a trial. I think we need to do things on the record in an open format.
And Your Honor, may I respond to that?
Okay.
So we're adhering to, number one, no speaking objections. And in a case like this, where a lot of it is emotional and passions, the jury should not hear, for instance, just this. This would be a proper conversation outside the presence. It is way easier than having them go out every time an objection goes to approach it. And then the things that we need to put on the record we do. You always indicate whether you sustain or deny the objection, so the record is preserved. But I don't think this conversation was appropriate to have in front of the jury prior to.
All right, well, it's certainly highly unusual, rather irregular to have these continued huddles. To the extent there are sometimes objections made, and then you come here and discuss it with me and with the prosecutor. And then I make a ruling. I've always given you the opportunity, if you want to put on the record the nature of your objection. You may. A few times you have. Most of the time you haven't. So I would consider that's your prerogative. You most likely waiving most of those objections because you're not putting any basis on the record for them. And many of our discussions here at the bench haven't been truly formal objections as much as you raising concerns about witnesses, responses and things like that. I agree with Mr. Herron that the record should be clear on what the objections are, the reasons for it, and what the rulings are. And so when there's been just simply an objection, with confidence, we don't follow up with that, figure that's on you. But it's we need to have more significant discussion. It's appropriate to have the jury out. I do appreciate the not having speaking objections in front of the jury. When I say no speaking objections, I typically think I want the objection for the rule, the reason, the response. It doesn't cancel anything. Objection, of course. I just don't want lengthy argument in front of the jury that could be used to influence the jury. So simple objections, I would expect you to just simply make them from the table and correct you on them. If it is complicated enough, you need to approach, and we need to do it outside the presence of a jury, I'll leave that for you to tell me, and we'll move forward. In terms of this objection, it is, I think it is certainly fair cross-examination to inquire Dr. Hanger if there was a prior suicide ideation or report of such, and how that would impact his opinion. I guess I can look through the rough transcript. I seem to, it seems like there was reference to that made by Dr. Hanger, but even if there weren't, assuming counsel has a basis on which to ask this, it's a fair question. It's not outside the scope. The scope of this testimony is the risk factors and how it relates to an individual's likelihood of self-harm. And so even if it wasn't asked on direct, there's a basis for it. The evidence is in the court. The evidence has been presented to a jury just in terms of the video testimony yesterday. And so it's, there's some basis for defense to inquire into this. And again, I think it's perfectly fair cross-examination. And so I'm going to overrule the objection and allow you to cross-examine on that when we return from the floor. We'll return at 1:30. Continue with Dr. Anderson.
All rise.
Supplements. Okay. So you
Potentially.
and that was
Okay, let's bring in the jury. You may be seated. All right, back to overrule the objection and continue the cross-examination of counsel.
Thank you. Good afternoon, Doctor.
Good afternoon.
Where we left off, we were talking about how a previous experience of suicide ideation can be a factor in a person's suicidality, correct?
It's something I take into consideration, yes.
Okay. And you mentioned that in your review of the materials, there was a reference of a possible previous incident of suicide ideations that was discussed in the initial interview with Mr. Howard, correct?
That's correct.
Did you talk to White Howard at all to confirm any of those findings?
No.
And you reviewed the full police file?
I can't be certain what you mean, full police file. I had a police report,
Just one report?
an incident report of, excuse me, police report 21-04578, and then a second police report that included supplements.
Okay. So you have some supplements?
Yes.
Were you aware of a second search warrant on February 17th, 2021?
The date doesn't come to mind. Location?
Were you aware of a second search warrant?
I can't say it comes to mind, no, sir.
Were you aware if law enforcement obtained anything to give credence to that potential suicidal ideation?
I have a recollection of examination of one of the rooms, looking for damage done, potentially.
And that was where law enforcement picked up a portion of carpet and confirmed whether a bullet hole went through where Mr. Howard said it would,
I only know that it was confirming that there was a bullet hole.
in the location they searched.
Correct.
Now, divorce has an impact, as you mentioned, in a person's emotions, correct?
It can, absolutely.
Particularly if one is waffling or going back and forth on whether they want a divorce or not.
When you indicate that it can have an impact on emotions, the waffling is an indication of the person's adjustment, good, bad days, information that may sway them. So the waffling of emotions, as you refer to, is an indication of how they're adjusting. Waffling of the divorce settlement, I don't have information about that.
She was having a secret affair, correct?
There's reference in the witness statements that there was a relationship, yes, with Mr. Pryor.
Her best friend didn't even know about the affair, correct?
One of them did not, that's correct.
Her parents didn't know about the affair, correct?
I read the mother's, Janie Wilkins' reference to imply that she was aware there was a closer relationship, and that in the Facebook messaging there wasn't a direct reference to a romantic relationship, but a stronger relationship than just friends.
That affair was exposed the day before her passing, correct?
To whom?
There was an argument between her brother Brian and Kendy regarding the affair, correct?
There was a Facebook exchange where she, the victim, expressed her concern that her brother may have shared information with the defendant about her having a relationship with Mr. Prado.
And in that that conversation, Brian blocked Kendy, correct?
She had stated that as her belief. I can't tell for certain if he did.
In fact, the last text message she sent that night, around just before 9 o'clock on the 2nd, was about her brother blocking her, correct?
One of the last, yes.
She did not have a job lined up in Kootenai, did she?
Not to my knowledge, no. She had considered, as I understood, asking for, she'd been given some resources, so asking about jobs, but she was not set for employment yet.
She talked to Mr. Prado specifically about not being able to get the job at the healthcare center down in Kootenai, correct?
I recall that she did not have a job set up. I don't know that she said that she failed to secure that one.
She would not be able to close on a house without a steady stream of income, correct?
Objection, hot foundation. No scope, correct?
Sustained.
You mentioned in your report, is it correct that 31.4% of females that commit suicide use violent means, correct?
Do you have a page number?
7?
Thank you. Uh, 31.4% use firearm.
Now, that's taking from the general population of male versus female, correct?
Correct.
That percentage goes up when compared to households that have firearms, correct?
In fact, that percentage is skewed because of the the greater number of males that commit suicide with use of handgun, and the increase in deaths in general increase when there is a gun in the home.
Is it true that constant misspellings can be an indicator of potential issues with emotions?
There's actually lack of foundation. Cause of speculation.
Foundation, he's a forensic psychologist, and Foundation is based upon his review of the text messages, Your Honor.
If he has foundation to answer that question, we can. I don't know.
In my review of the Facebook messaging, I saw typos, abbreviations, slang used in all parties.
When an individual consistently uses misspelling, can that be an indication of emotional issues?
I wouldn't make a conclusive statement. It can mean that they're texting while they're driving. It can just mean that they are typing too quickly.
Your assessment of Kendy being positive, having a positive, hopeful outlook, was based upon the interviews between her direct family and law enforcement, correct?
As well as her friends, yes.
Ms. Howard was 48 years old when she passed. Menopause can have an effect on a person's emotions, correct?
Yes.
Self-care can also be a sign of a person being unhappy with one's image, correct?
Not as you're implying. That the self-care actions can be an indication that a person is taking control of the stressors in their lives, acting in a manner that they feel may help to relieve some of the distress that could come with the self-image from natural aging, childbirth.
A tummy tuck is a extreme procedure, correct?
I don't have a comment on that, sir.
Her secret life was falling apart, correct?
Objection, argument made. Also, foundation.
Sustained.
You would agree that your information was based upon the information provided to you, correct?
Yes.
And while it may be difficult to predict suicidality, increased confidence of self-harm can be obtained from the direct evaluation of an individual, correct?
Yes.
No direct evaluation of Ms. Howard was conducted, correct?
None was available, no.
It is not possible to provide an absolute predictive determination of suicidality from a records review, correct?
The process is never to determine an absolute predictive. There's medicine, mental health is not an exact science. So our process is to determine probability, increased probability. So I am, in fact, tasked, called upon by the court in my profession to make the best prediction based on probabilistic information from records, from the direct interview if available, from friends, family.
You specifically put in your report that it is not possible to provide an absolute predictive determination of suicidality from a records review, correct?
Yes, correct.
No further questions.
Redirect.
There was no direct evaluation of Kendy because Kendy was deceased by the time that you were involved in the case, correct?
That's correct. Yes, sir.
And there was no direct evaluation of Kendy at all in the medical records because she had no history of mental illness, right?
She was, on an ongoing basis, being screened by her medical providers. There was a constant request for her to answer questions that give an indication.
I did have an
I'm
objection.
sorry.
I apologize. No, I thought I heard you say objection, but I wasn't sure.
Yes, Ron. Objection, mischaracterization, your objection.
Overruled.
Go ahead and finish your answer, sir.
There was an ongoing assessment of Ms. Howard by her medical professionals. As standard practice in medicine now, mental health screening, domestic violence screenings. When there's certain medications prescribed, there's further screening as well, as was indicated in the medical records.
You indicated in speaking with counsel that your assessment of Kendy having a positive outlook on life was based upon the many interviews law enforcement did with family and friends. Is that accurate?
The interviews and the Facebook posts, the Facebook messaging posts.
And then I think earlier in direct examination you said with the exception of her husband. Is that true?
Individuals throughout the records, with the exception of her husband, referred to her as having a positive mental state just prior to her death, and did not raise indication of concern other than her husband that she had a mental illness.
And so when you say other than her husband, you mean Dan Howard?
Yes, the defendant.
And what do you mean by that?
The Facebook posts indicated Ms. Howard was aware that he had suggested she get mental health treatment because of her emotional responses, that she had bipolar, that he had in his Facebook response indicated he knew as much as a shrink does, and that was his recommendation. She then responded to friends that I'm not crazy, I don't have a mental illness, and she declined to pursue that.
When you spoke with counsel about some prior suicide attempt, what was that based on?
The only reference was in the defendant's statement to the police that he had witnessed the victim placing a gun to her head and then discharging that weapon into the floor. There was no other witness to that event.
So it was the statement of Dan Howard standing alone that she had done this that basically gave any sort of support to that idea whatsoever?
That's as far as I could see in the record.
And that would be the same person that had the only concern about her mental health as opposed to all of her family and friends?
That, yes.
Counsel named a number of life stressors that Kendy was going through. Leaving a job, perhaps finding a new one, getting divorced, moving, things like that. Did you take these things into account when you came to the conclusion that she was at minimal risk for suicide or no risk?
Yes, as part of my assessment, that is the initial process, looking for mental illness, looking at stressors, looking at her hopefulness, and so I did take into account all of those stressors that clearly for Ms. Kendall, she was experiencing a significant level of stress in her life at that time.
Okay, but despite that, do you think the risks were outweighed by other evidence?
I would use the term mitigated, reduced, addressed, and it's not a matter of, it doesn't remove that. She was still likely going to go through a divorce. It appears that she was in the process of closing on a house, so it's not the control of the stressors, but how she copes with those. So what her mitigating factors, her social contact, her outward activities in life, the socialization she had, her ability to adapt to those stressors, that was what helped me to reduce the consideration that, okay, with these stressors, because not everyone who has stresses in their lives, not everyone going through a divorce, buying a new house, is going to contemplate suicide. But if an individual is forward-focused, looking at what is in my future, is still functioning, then these stressors don't have that negative outcome.
Like she was.
Exactly.
No further questions.
Thank you, sir. Any further witnesses from the state?
Your Honor, the state just finished with its last witness, and at this point, the state would like to rest.
All right, state having rested, I need to take up some matters outside the presence of the jury. I can't tell you how long or short this could be. I anticipate it's been a little bit of a longer break, just so you know. We'll be back to you as soon as I'll excuse the jury at this time. You can see. Mr. Johnson, you indicated you have a motion for the court?
Yes, Your Honor, just, would the court want to take up Dr. Howard's issue?
I'll take your motions first.
Okay. Your Honor, I'll keep this brief, but we would ask for a directed verdict at this time. In summary, short summary, the state's case relies solely on what they quote-unquote call lack of blood. However, there's ample evidence in the record and exhibits to show that there is blood pooled, coagulated, down in the tub, matted in the hair, caked on the back, and not one witness has addressed the differences between, one witness, Dr. Rambran, his only explanation for the blood there was that, basically if you go, and this was how he held his hand, if you go transport to the medical center through the Rockies, then liquids might or fluids might escape the body. The whole theory of the case relies specifically on the lack of blood. And specifically, I'm not saying that had the state kept its original theory of asphyxiation and or gunshot, that I would be able to make this argument. But the state having changed its theory to by asphyxiation, there is no evidence before the jury to show what accounts for the matted hair, what accounts for the caked blood. The alleged domestic violence, whether it's lividity, and Dr. Schmock talked about that, that's not related to the cause of death. The cause of death is by asphyxiation, according to the state, according to the charge. They have not met the burden of death by asphyxiation, and I believe that the court would find that if they kept the original theory, it's probably more likely than not that their stronger theory would have been death by gunshot. Based upon that, we would ask for a director.
Response from the state?
Yes, Your Honor. First, I interpret the defense's motion as only applying to count 2, not
Correct.
count 1. So I won't make any argument in support of count 1, other than I believe there's sufficient evidence to support the charge. Regarding count 2, Your Honor, this court and the jury has heard competent and credible evidence supporting the charge that Dan Howard murdered Kendy Howard in the first degree. Your Honor, that evidence is that on February 2nd, in Kootenai County, Idaho, Dan Howard caused the death of Kendy. Evidence showed that this was not a suicide. Kendy had future plans. Kendy was leaving Dan. Medical and expert testimony demonstrated to the jury that this was not a suicide. Among the many things the jury heard was the fact that there was an extreme lack of blood at the crime scene. And that lack of blood was explained through a degree of medical certainty by more than one doctor that the gunshot that Kendy suffered happened post-mortem. So therefore, this was not a suicide. The jury also heard competent and credible evidence that this was a homicide. A lot of testimony was given, evidence of asphyxiation. And that is the state's theory, Your Honor. The state's theory, and the evidence shows, that Dan Howard, the only person in the house when Kendy died, had the knowledge, opportunity, and ability to strangle his wife. And he had the motive. She had just told him days before that she wanted a divorce. Mr. Howard's premeditation happened on January 29th, or even before that. After telling Dan Howard that she wanted a divorce, Kendy went to bed. She woke up in the early morning hours to Mr. Howard standing over her. And Kendy was convinced that Dan was about to kill her. And so between the 29th of January and the 2nd of February, Mr. Howard is planning and plotting her death. And finally, on February 2nd, his plan is executed. He caused Kendy Howard's death. Her body was riddled from head to toe in bruises and some lacerations. Competent and credible evidence, Your Honor, that this was of malice, that it was of forethought, that it was of premeditation. Mr. and Mrs. Howard were married. They were household members. They had a child in common. This is, again, sufficient, more than sufficient evidence upon every element of the state's charges, Your Honor. This was not a suicide. This was a murder. The jury has more than enough evidence to make that decision for themselves. This is not a case where the jury should be deprived of the ability to consider the evidence that was given. And so I can't object any stronger than that to the defense's motion, Your Honor. Thank you.
Thank you. Final word, Mr. Johnson?
Thank you, Your Honor. Your Honor, to be clear, this isn't about alleged batteries or bruises, and whether the bruises were lividity or not. This is about asphyxiation. Dr. Smock specifically testified that the only way you can be asphyxiated and not show signs of petechia is to do a chokehold in a manner that officers are not trained on. That's assuming that there is a lack of blood. Because the issue is, where's the blood? There's evidence. The state submitted the evidence in the photos of again, the body coming onto the gurney table, hair matted with blood, which is consistent with the photos showing the blood pooling in dark pools above the shoulders going to the hair. The state has not posited a theory on where that blood went, why there's so much blood, and why there's no petechiae from the carotid restraint that law enforcement is trained on. Because the testimony from Dr. Smock is the carotid restraint would cut off 80% of the blood flow. But you need 100% cut off. You need to do like a rear naked choke to asphyxiate without petechiae. Again, this is technical as far as the state just chose at the last minute to do what they did and just do asphyxiation. They have not met their burden that there isn't enough blood and that Mr. Howard did a stranglehold that he wasn't trained on, and we don't have any training records at all that he even learned it. So, again, I do think that while technical, certainly it doesn't address the first charge, but I do think it addresses the state's. I don't think it addresses, we can take it up later, but I don't think it addresses the alternative of second-degree murder as well.
Thank you. Well, under the Rule 29 motion for acquittal, the courts to independently evaluate the evidence and testimony to determine whether or not a reasonable juror could find the defendant's guilt beyond reasonable doubt. I do find that to be the case. While this is a circumstantial case, the evidence presented by the state is substantial, and I certainly think a reasonable juror could come to the conclusion that Mr. Howard is guilty beyond reasonable doubt. And so I'm denying the Rule 29 motion at this time. Did you have any other motions, Mr. Johnson?
Not at this time.
All right. Does the state have a motion to exclude Dr. Howard? I'll hear you on that motion.
Thank you, Your Honor. State filed a motion to exclude Dr. John Howard. We would note that the state became aware that John Howard was going to be called as a witness during trial when Mr. Johnson issued a subpoena for him. Mr. Johnson in his response to the state's motion, seemed to indicate that the state was playing games with its witness list. And so I'd like to clarify that before we get into the reasons why Mr. John Howard should not testify. John Howard left the Spokane Medical Examiner's office within months of Kendy Howard's autopsy. He canceled his medical license in the state of Idaho, and he let it lapse in the state of Washington. Before he left, he communicated to coworkers that he was done. He did not want to do this job anymore, he didn't want to respond to subpoenas anymore, and he wanted to retire. And frankly, Judge, that's what he did. The state did not know where John Howard was. And so when the state witness list, first, second, third, all said to be provided, that was because the state did not have contact information for John Howard. Now, if the state were playing games, as Mr. Johnson seems to be alleging, the state could have dropped John Howard from its witness list. But the state believes that there was a potential foundational factual need to keep John Howard on the witness list and engaged in ethical actions in attempting to locate John Howard. Got a tip that he'd moved to be closer to his grandkids, whether that was Idaho, Washington, Connecticut, or Georgia. The state didn't know, and there certainly are a lot of John Howards in the world. So the state did take efforts, using its internal investigators, to locate John Howard, get an address, and provide that. But what wasn't happening while the state was making those efforts is that Mr. Johnson was not complying with the basic principles of ICR 16. ICR 16 requires that expert witnesses, their reports, their curriculum vitae, and the information used that they rely upon to create those reports be provided to the opposing party. Even more so, Your Honor, in this particular case, there were scheduling orders in place, not once but twice by this court, providing deadlines for the parties to provide that information to one another. At no point did the state provide to Mr. Johnson a CV for John Howard. At no point did the state indicate that it was going to call John Howard as an expert witness with a notice, as it typically does. John Howard was not called at the grand jury, and there was nothing in the record to indicate that the state was going to be utilizing him as an expert. Likewise, Mr. Johnson filed a witness list in, I believe it was June of 23. On that witness list, in his lay witness section, he indicated that he reserved the right to call any witness on the state's witness list, certainly. And then his expert witness section, he listed two experts, Dr. Jeffrey Desmoulin and another individual, I think by the last name Liorda. Ultimately, in concordance with the deadlines provided by the court, Mr. Johnson did provide an expert witness report for Dr. Desmoulin. That is the only expert witness report that the state received from the defense. John Howard cannot come into this court and make expert conclusions. John Howard cannot come into this court and make expert opinions. John Howard authored a report one day after Kendy Howard's death. He did so by making an examination of her body, and certainly, if he were necessary as a factual witness, I think that an argument could be made that he would come in and make factual statements about what he observed, what he saw. But what he could not do, Judge, would be to go beyond that, to make conclusions. The state has received no notice as to what the defense has provided to John Howard about, did he review the grand jury transcript? Does he know the state's theory of the case? Was he provided Dr. Desmoulin's report? Was he provided the coroner's photographs? We don't know. We don't know what his opinion is going to be on those things. We don't know what his opinion is going to be on anything related to anything beyond day 2 of this case. That is not providing the state with sufficient notice of his expert opinion. And Judge, whether or not John Howard testifies as a fact witness, the photographs are in evidence. The examination of the body is in evidence. That came in through Jennifer Nara, and Mr. Johnson had every opportunity to talk about that with Jennifer Nara. To now bring John Howard in and to say, this is the same photograph, this is the same photograph, this is the same photograph, is cumulative, Judge. It's irrelevant and it's cumulative. And so, Judge, for those reasons, we ask that the court exclude John Howard. He has not been properly noticed. The state is not on notice as to his opinion, and any testimony that he would provide at this point on a foundational and factual basis is cumulative and irrelevant.
Thank you, Mr. Johnson.
Thank you, Your Honor. Again, you got my briefing here, but I think it's a little, I don't know necessarily disingenuous, but from day 1, since receiving discovery, we've known about Dr. Howard. From day 1 of receiving grand jury transcripts, almost every single oral argument in this case has referenced John Howard. He is a necessary witness. He is the only one to have physically, freshly, professionally examined the body. The state, even though they didn't put him on the grand jury, the state elected to put him on their witness list. Again, grand juries, you don't put all your witnesses in a grand jury. You put on enough to make a case to convince them on a more likely than not basis or probable cause basis that a crime was committed. So we understood that Mr. Howard or Dr. Howard would not be in the grand jury, but it was on their witness list, and there was 5 different witness lists. In the fall, after we started realizing that the state, based upon their arguments and motions, might not call Dr. Howard, which we still believe is a necessary witness, it took my investigator probably 15 minutes to look up his phone number. I have not provided Dr. Howard with any expert opinion. His opinion would be limited to the report that he conducted that was provided to defense. I don't know why I would have to provide the state their own report. As far as him retiring, he has testified since retiring in over 7 cases where he has performed the autopsy and or reviewed the autopsy. The state is soliciting unsubstantiated at this point statements about why he may have left. That's certainly a subject to cross. This should be a search for the truth, not a trial by ambush. And it does feel like an ambush because of particular note, especially since from day one, we've been arguing about this, about Dr. Howard's testimony. The state has never filed a motion, just like Dr. Desmond, and maybe it's tactics, but it should be a search for the truth. That had they filed a motion prior to exclude Dr. Howard after the discovery deadlines, which other than CV, we've complied with because we have the right to call their witnesses and they have his report. We don't have an additional report that he's relying on. He's relying on his report. He was the subject of 2 motion eliminates in this matter, number 9 and number 14. And specifically, number 14, the state requests that we can't bootstrap our opinion on, not our opinion, Dr. Howard's opinion on another expert. Your Honor knows we've had multiple conversations with that. Never in there is like, well, he wasn't disclosed. No, that was never an issue. But to wait until Dr. Smock and Dr. Nara testify, then file this motion is a trial by ambush. Procedurally, we're not going to submit a CV. I'll ask him about training experience, but I'm not going to submit an exhibit that he didn't provide to the state. That would be improper. They have his opinion. He's a necessary witness, the only one who touched that body fresh as far as autopsy forensically. And it's necessary for the jury to get to the truth of what happened. And if he would be excluded, we would be asking for the necessary jury instruction, which was the subject of the motion to eliminate. And so we do think procedurally we have complied. It's not our obligation. And in 3 years of this, the state has not reached out to him one time. It was not hiding. It didn't take long to find. It didn't take an active investigation. So certainly the state was aware that we were calling him, both by our pleading and by our numerous records, and he's a necessary witness, and the state is at no surprise, Your Honor. And frankly, every single expert has relied on his opinion. He's a necessary witness to offer that opinion.
So if you understood all of this, why didn't you list him as an expert witness? It seems like he's your number 1 expert witness. Why didn't you list him as an expert witness and provide his opinion to the state?
So the state has his opinion.
Well, have you talked to him since?
I've confirmed that I got a hold of him, confirmed. I confirmed that he'd be willing to testify. I have not subpoenaed him. I started to, but I have not subpoenaed him. He is going to be here tomorrow.
Have you discussed his opinion with him?
I discussed his opinion with him. I have not shared any other experts' reports. I have not talked to him about Dr. Morrow. I have not talked to him about Dr. Desmond.
And you didn't think you had an obligation to tell the state what his opinion was going to be, pursuant to the scheduling order and the rules of discovery that require expert witness disclosure?
His opinion is the autopsy report, Your Honor. That's his opinion. That autopsy report is his opinion. That's what they provided to us. So it hasn't changed.
You've told the state he's going to be an expert and his opinion will be the same as it was?
That's what it is, Your Honor. I
I
it's the
can't
same as
tell you that right now, but the whole point of having discovery and pretrial discovery orders and disclosure orders is that the state's not, neither side is surprised.
If we look at it in reverse, Your Honor, as mentioned in my motion, if I were to be up here right now making the same motion, the state would be saying, hey, look, he was on 5 witnesses lists. 5 witnesses lists, even though we didn't call him for the grand jury, even though we had these motions, he's on 5 witnesses lists and you have his opinion. I would have no legal basis to object to...
You mean if the state didn't disclose him as an expert?
No, if the state called him as a witness. Because he's listed, they didn't separate out. I separated out in my pleadings, the additional witnesses. In their pleading, they do not separate out expert versus lay. It is one long list. I assume people are experts based upon reading the grand jury, or they have a, like Mr. Beasley, he's not a doctor, but based upon the grand jury, I knew that he was an expert. They don't separate. I, for convenience, separate out potential experts that I am calling.
So what do you think Rule 16 requires of you as relates to expert witnesses? When it says on written request that the prosecuting attorney and the defendant must provide a written summary or report of any testimony that the defense intends to introduce pursuant to Rule 702, 703, or 705 of the Idaho Rules of Evidence, the summary provided must describe the witness's opinions, the facts and data for those opinions, and the witness's qualifications.
If we think of it this way, Your Honor, in answer to the question, the state, had they called him, complied with that. We are calling their expert. We put them on notice of calling anyone. This is their expert, not our expert. It was listed in their disclosures. We were provided his opinion. His opinion has not, we're not offering a different opinion. We're seeking the opinion that we were provided by the state in their disclosures. And we made that known, not only in our reply to our witness list, but also frankly, I think the state should have called him. But that's neither here nor there. If their pleadings conformed with Rule 16, and it's their opinion that was provided to us, it'd be like if I were to provide them Desmond's opinion, and for some reason they got wind that I wasn't going to call him, and they put me on notice that they had the right to call any of my witnesses, they certainly could call him and use the opinion that was provided. I said, that's what we're doing, Your Honor.
I doubt that, but okay. Anything else you want to say?
Even if he's not allowed to give an opinion as to overall cause of death, I think that's the issue that the state has. He's a necessary fact witness, having done the autopsy.
All right, thank you. Ms. Shostak?
Thank you, Judge. I would refer the court to the I-Court's record, wherein the state filed 18 separate supplemental responses to discovery regarding expert witness for each and every one of our expert witnesses. That would be separate and distinct from our witness lists. So expert witness Bryant Gunderson, expert witness Dean Livingston, Morgan Ford, Dr. Nara Philip Hanger, Dr. Raber, who was not used, Dr. Ren Baring, Dr. Smock, Dr. Stewart, Gary Tollison, Janet Ayers. I can go on, Judge. The point is that the state absolutely complied with Rule 16. The witness list is not intended as an expert disclosure. The witness list does not comply with Rule 16. The state filed 18 separate notices of intent to use expert opinions, which all included a curriculum vitae and either a separate written opinion or a reference to the grand jury transcript for those witnesses that testified at grand jury. Again, nowhere in those 18 separate filings did the state indicate Dr. Howard. Judge, my concern with John Howard coming in to testify as a, quote, foundational witness is that Mr. Johnson is not going to stop short of the cause of death. Mr. Johnson repeatedly attempted to get John Howard's opinion as to cause of death in through other witnesses throughout this trial, and ultimately the state acquiesced to that as a tactical decision. However, what I anticipate Mr. Johnson doing is bringing him in and saying, isn't this lividity, or is this a bruise? Those are opinions, Judge. Those are medical opinions that John Howard is going to be questioned about and ultimately cross-examined about. And to say that there's been no conversation about what he's expected to testify to, Judge, it's baffling. And so, Judge, the risk of Dr. Howard coming in and testifying, it's going to go into expert opinions that he should not be allowed to testify to. It's going to go into areas that the state is not on notice about, and it is, beyond that, cumulative. Thank you.
Thank you. Well, in considering this issue, case law is clear that a criminal defendant's right, and I'm quoting from State v. Siegel, the criminal defendant's right to offer testimony is derived from the Sixth Amendment's compulsory process clause, and that right can be violated by the imposition of a discovery sanction that excludes the material defense of the witness. However, the right to present exculpatory evidence is not without limitation, and it goes on to say the adversary process cannot function effectively without adherence to rules of procedure that govern the orderly presentation of facts and arguments to provide each party with a fair opportunity to assemble and submit evidence that contradict or explain the opponent's case. Thus, the determination whether to exclude a defense witness for late disclosure is committed to the trial court's discretion. In exercising this discretion, the trial court must consider whether the state would be prejudiced from the late disclosure if the evidence were admitted and weigh that prejudice against the defendant's right to a fair trial. Case law goes on to talk about whether it's defense counsel's failure to disclose or the defendant is essentially part of that willful failure to disclose. In this case, it's clear to me that defense counsel has failed to disclose Dr. Howard as an expert witness. I don't see any involvement from the defendant himself with regards to this. So I see this solely as defense counsel's failure to disclose. And I do note that I disagree with counsel's version of how the rules of discovery work. And I believe that counsel was under an obligation under Rule 16 to disclose Dr. Howard as an expert witness and in the requirements under that discovery rule, and he did not. And so sanctions may or may not be appropriate. The ultimate sanction is exclusion of a witness. And that's what the state's asking me to do here. In excluding the witness, I have to consider the state's prejudice. In this case, I don't find any significant prejudice to the state. Dr. Howard has been known to the state from the very beginning as the medical examiner who conducted the autopsy the day after Ms. Howard's death. His report has been available to the state for around 3 years now. There's never been any surprise here that Dr. Howard determined the cause of death to be by a gunshot. That's not. The state has known that from the very, very beginning. At the time Dr. Howard made that finding, he was in fact maybe not an employee of the state, but a contractor of the state, of the county, for doing autopsies, medical examinations as a pathologist. And so it is somewhat fair to characterize him as a state's witness. The state has argued in motions in limine that Dr. Howard's opinion should not come in unless and until such time as he testified and gave that opinion of the court, which I did rule. There was significant question pre-trial about whether or not Dr. Howard would even testify. Even Mr. Johnson indicated he didn't know if it would happen here, but if he did, he was hoping to have him testify. It was that uncertainty of whether or not he would even be available for trial to testify, which is why I sustained that objection in the opening statement to referencing his opinion, because it was even unclear if he would testify. But if he did, there was never any surprise about what his testimony would be. And to the extent, as an officer of the court, Mr. Johnson, I'll accept your representation that he hasn't reviewed other experts' reports, testimony, etc., that he has developed no new opinions. He's simply being called to testify consistent with his opinion in his initial report some 3 years ago. Given that, I don't find sufficient prejudice to the state that would permit the exclusion of what is possibly one of the defendant's most important witnesses, which is almost his only witness to contradict the state's medical witnesses. I'm not saying he's going to successfully do that one way or the other, but the defendant has a due process right to present his defense, and to exclude that, I think, would be an abuse of discretion and extremely harmful to the defendant's right to fair trial, where I don't find the defendant himself having any role in this late disclosure. In Idaho, one of the cases I reviewed, they approved a monetary sanction on defense counsel to impress counsel with the importance of following the rules of procedure and discovery. And I may do that. I may impose a monetary sanction on defense counsel for not complying with discovery, but I'm going to reserve my judgment on that for this moment. But ultimately, I'm not going to exclude as the ultimate sanction Dr. Howard. Now, should the state, I'll allow the state to continue to, if they can demonstrate some prejudice after his testimony that would require a short continuance or a short delay in trial for them to respond, I would consider that. I do think this is a surprise to the state, given that Dr. Howard was not listed as an expert witness by defense, and I think the state anticipated him not being called, which wouldn't be the case had defense counsel just simply taken the very easy step of listing him as an expert witness. We wouldn't be in this situation. So, should the state need extra time to respond, I would consider that request down the line. But I think exclusion would be an extreme remedy, and it's not warranted in the circumstances. Also, as to it being cumulative, I don't find this to be. It's not that cumulative alone is the issue. It's unduly cumulative to the point where it's unnecessary, distracting, or confusing to the jury. It's certainly not. I don't think his opinion is. I have not allowed much discussion of his opinion for the very reason that I ordered ruled in motions in limine that his opinion can't be bootstrapped by other experts. And so his opinion has been very, very limited in any discussion of it before the jury. I think it may be just almost solely in the death certificate that was admitted. And so the defendant's ability to present Dr. Howard's observations, performance of the autopsy, and his conclusion, I don't find that to be unduly cumulative or unnecessary, but rather I think it falls squarely within his due process right to present defense. I'm not further limiting his testimony other than it has to be within the confines of his report. So with that, I'm going to deny the motion to exclude. Are you prepared to call your first witness?
Yes, ma'am.
Okay.
Just one thing before we move off that issue.
Yes, ma'am.
Would the court consider requiring the defense counsel to turn over John Howard's phone number to the state so that the state could prepare?
Absolutely.
Thank you.
I'll ask you to do that right now. All right, we'll bring the jury back in. And then we have to see Mr. Johnson. seated. Members of the jury, the state having rested, it's now the defense's opportunity to present their case. Mr. Johnson, you call your first witness.
We call Mr. John Howard.
Mr. John Howard. Good afternoon, sir. If you come forward, please. I'll have you face my clerk, and please raise your right hand and be sworn in.
Do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you, sir. If you have a seat right there at the witness stand. You may inquire.
Good afternoon. Can you please state your name and spell your last name for the record?
John, middle initial E, last name Howard, H-O-W-A-R-D,
And where do you live?
in Lucille, Idaho.
Where's that in relationship to, say, Riggins?
It's about 8 miles north of Riggins, Idaho, and 26 miles south of Rangeville.
Okay. What's your background? What do you do for work?
I'm retired.
Where did you retire from?
I've had several occupations. I was in law enforcement. In the last 15 years, I was logging.
Okay. Do you know Dan Howard?
Yes, I do.
How do you know him?
He's my son.
Do you know Kendy Howard?
Yes.
How do you know her?
She is my daughter-in-law.
You know Brian Howard?
Yes.
Who's he?
What was
I'm
that?
sorry, Brian Wilkins.
Wilkins?
Yes.
Yes.
And who's he?
He was Dan's brother-in-law.
And then finally, Wendell Wilkins. Do you know him?
Yes. Wendell was Kendy's dad.
Okay. Can you just briefly explain where you were living when Dan was growing up?
When Dan was growing up,
Yes.
and when Dan was growing up, we were living in Hayfork, California, and I worked for the sheriff's office. He went to school. Hayfork's a little logging town. It was all supported from the logging.
Okay. At some point, did you move up to Idaho?
Yes,
And when was that?
that was when I was 40 years old, and about 40 years old, and I went took a job with the state brand inspector's office in the state of Idaho.
Is that where Dan graduated high school?
Yes, Dan went to school in when he came to Idaho, in Meridian, Idaho, and also in Lewiston. I was transferred to the Lewiston office, and he graduated from Lewiston High School.
Okay. When did he meet Kendy?
He met Kendy after he was had gotten out of the Marine Corps, and at that time was working for the Idaho County Sheriff's Office.
Do you know when they were married?
I beg your pardon?
Do you know when they were married?
Yes, now it's been, I can't remember the exact date, but now it's been about 30 years ago. And
After they were married, did they live in the Lewiston area?
did what?
Did they live in the Lewiston area?
They, yes, he lived in Idaho County, and then they moved to Lewiston when he went to work for the state.
At some point, did they move up to Apple?
They did, and he'd been employed by the state for, I can't remember exactly, 5 or 6 years, 4 or 5 years.
So, from the 5 years prior to Kendy's passing, where was Dan working, to your knowledge?
He'd been working in North Dakota and Alaska, and for 4 or 5 years.
In your understanding of Dan, how would you describe his normal demeanor?
Objection, relevance.
Those foundational.
Foundation of what, Judge? It's not relevant.
Well, it's been addressed by the state in their case, and so I'll allow this as overruled.
So, Mr. Howard, how would you describe Dan's normal demeanor?
His normal being or
Demeanor.
demeanor. Usually, he's very, very exacting in projects that he started to complete them. Pretty much family man, and
Objection. It's non-responsive to the question that's asked. In terms of demeanor.
There was not a question before the witness, so I'll strike the last answer. So wait till he asks you a question. Go ahead.
Would you describe him as a family man?
Objection, relevance, Judge.
Sustain.
In your interactions with Dan, did you personally witness any issues with, say, hearing?
With his hearing?
Objection.
Yes.
No foundation. This could have been when the defendant was a baby as opposed to 50 years old. No foundation for this question.
This is foundation.
You can establish your foundation. Go ahead.
Did you have opportunity through the course of Dan's 50-plus years to observe his physical effects?
For his physical effects?
Yes.
Well, he maintains himself in good shape, except for he can't hear out of his left ear.
And do you know that from personal experience?
Yes.
Can you explain?
About 10 years ago, he had a ear infection that, for a while, it affected his
There's your
equilibrium.
foundation, and it's also calling to the hearsay answer.
Let me rephrase, Your Honor.
Response?
No, I agree, Your Honor.
It's the same.
From your personal experience, I don't want to get into what, doctors or anything, but
Oh, yes,
from your personal experience, have you witnessed this hearing?
Yes, when you talk to him, he pretty much has to be looking at you and see your lips move to understand you.
Around the end of 2020 and 21, were you aware of a possible pending divorce between Kendy and Dan?
Yes.
Okay. Were you aware of that prior to or after February 1st of 2021?
Yes.
Which one? Was it before or after?
That was before, a couple of days before.
Did Dan come down to your place on February 1st, 2021?
He did.
Okay. Why did he come down?
He came down to visit. Dan and Brian Wilkins both came down to visit.
So Brian was with him?
Yes.
Can you describe, did they stay with you that night?
What was that?
Did they stay with you that night?
Yes, they did. I had company. A friend of mine was, I just brought another load. I was still moving in. So there was 4 of us there, and they came down, and I was unloading another load into my shop and into the hay barn, and when they showed up. So
What time do you think they showed up?
that was in the afternoon, about it was 1 or 2 o'clock in the afternoon, I think.
Okay. Did the 4 of you then have dinner together?
Did you what?
Did you have dinner together?
Did you have?
Did the 4 of you
Yes.
have dinner together?
Yes, we did.
Okay. And did the 4 of you stay in your house that night?
Yes, we
Can-
barbecued steaks and went to bed probably 10 or 10:30.
Okay. Can you explain a little bit how your house is laid out?
Yes, it's an older log home, and it's about 2,800 square feet. The bottom floor is a large kitchen with an island, and then there's a large kitchen table, and then there's a stairway in the center of the house, located central in the center of the house. It goes upstairs. There's a walkway around that stairway that goes to the living room area and my office area. And there's 4 bedrooms upstairs, and 2 couches and lounges downstairs in the living room. It's a large living room. And
Is your room one of the 4 rooms upstairs?
yes, my room is a master bedroom upstairs. It's just a little larger than the other 3 bedrooms. There's double beds in there's double queen beds in the 3 spare bedrooms.
Where did the others sleep that night?
Dan slept in the northwest bedroom, Brian slept in the northeast bedroom. Ken White had an old back injury, so he sleeps downstairs in a recliner to facilitate his breathing better.
Okay. Now, do you have any animals that sleep with you?
I do. She doesn't sleep with me. I have a well-trained cow dog, sleeps in a little dog bed that's next to the foot of my bed. As you can tell, I'm hearing impaired. I lost my hearing in combat, but I have that dog for a reason. She's trained. If she hears anything outside, she'll wake me up. She'll stand up on the side of the bed and grab my hand and let me know that there's something moving around.
Okay. What time did everyone go to bed around the same time that night?
It was around 10 or 10:30, and we all went up and went to bed, and the doors were, I leave my door open into a hallway. There's 2 bedrooms, there's a short hallway, 2 bedrooms on each end of the hallway. The hallway runs central, north and south, and Brian was in the east side of the bedroom in the northeast, Dan was in the northwest. The doors were, Dan's door was open, Brian's was closed, and all the nights there's a night light in the hall.
Okay. And so, To your knowledge, did Dan get up and pace at all that night?
No, that dog would have been up and getting me up if that would have taken place.
And the dog didn't get you up?
It did not.
What time did everyone wake up in the morning?
It was after daylight, and I don't recall the time. It's winter time, so it was well after daylight, and we all had coffee.
Okay.
And
So in February, do you know what time ballpark daylight would have been there?
the ballpark that we went.
What time ballpark?
Oh,
Okay.
It had to be after 8 o'clock because it was winter time and doesn't get light until after that time. So, and it was well daylight.
Okay. After you all got up and had coffee, what did you guys then do?
We all decided to go to Riggins and eat breakfast.
Okay. Is there anything, a particular place that you went to?
Yeah, some people had opened up a breakfast and lunch business in the old pizza place building, as it's referred to by the Riggins residents. And they served quite large breakfasts and good, and so we're all kind of big guys, so that's where we went to eat.
How long do you think you were at the restaurant?
How long?
Yes.
Well, they're not very fast at serving breakfast. It takes quite a while to get their orders. They fix them one meal at a time and keep them warm and then bring them out to you. And we were there at least an hour and a half before we got paid and out of there. And
when you left the restaurant, did you all leave together?
yes, well, Ken and I, my friend, we got in my truck, and Dan and Brian got in theirs, and we left from Riggins. And
Did you stop back at your house? Did Dan and Brian stop back at your house at all?
Dan had told me they were going to stop and look at some property that we looked at the previous day in Slate Creek. I don't know that they did that.
Did it appear that Dan or Brian were in a hurry?
No, we stood outside and talked for 10 or 15 minutes before they left.
And Riggins is, you said, to the south of Lucille, where you live?
Yes,
And so-
we followed them on the highway until Lucille, and of course I turned off.
So Riggins is the opposite way than Lewiston from your house?
Riggins is south of Lucille. Grangeville is north of Lucille.
Your Honor, the next area of questioning may take a little bit, or would the court want to take a recess now, or power through?
Maybe not yet. Let's keep moving. Thank you, Rob.
Now, John, where were you when you learned of Kendy's passing?
Well, Ken and I had,
Non-response.
Didn't get a chance to answer.
I'll go to the objection when I finish this answer.
You can answer.
Ken and I had gotten up early, fed the horses, and we were rearranging stuff in my shop. If you can break it, I have something to fix it in that shop, and it was in a pile. So we went to breakfast.
Time out. I'm sorry. When you hear an objection, just go ahead and stop.
Okay.
I know it might be hard, but if you see me times, just go ahead and stop. I'll ask another question.
Okay. And then we'll
When did you, or how did you learn of Kendy's passing?
By a phone call.
Who was the phone call from?
Dan.
Was anyone with you?
Was anyone with me?
Yes.
Yes. We were eating breakfast in that same restaurant when I got the phone call.
Could you, can you describe that process of what you did when you received that phone call?
Yes.
Or it goes to foundational to some other question.
What he did after he got the phone call has nothing to do with this case.
There's an issue of who was contacted or not contacted, brought up in the state.
Well, maybe you could make it a little more specific rather than just can you describe the process of what you did when you received that phone call. If you could direct the witness more specifically, I'll allow the question.
What did you hear, what was said when you got that phone call?
What was what?
What was said when you got that phone call?
Objection here, sir.
Did you understand what was going on when you got that phone call?
I had a very hard time understanding the Dan because he was crying and bawling, and finally he squeezed out what had happened. And I could barely understand it, so I got up from the table, went outside, and attempted to call him back.
Overruled.
You went outside and what?
I went outside and attempted to call him call him back.
Were you able to get a hold of him again?
Yes, but I couldn't understand him.
Okay.
He was quite upset.
Without telling me anything that your friend said, did your friend assist you in trying to understand that phone call?
Objection. It's going to be hearsay. It's also not relevant.
Okay.
Maybe what someone else heard the phone call be and explained it to this witness.
The question was, did your friend assist you in trying to understand the phone call? That's a yes or no question, so overruled.
Did someone assist you in understanding that phone call?
Yes, my friend, Ken White.
Okay. After you understood that Kendy had passed, did you try to make contact with Mr. Wilkins?
Yes.
After that, did you travel up to Athol?
Yes.
What day?
I took care of things and I got to Athol at about 1 o'clock or 1:30, I think, somewhere between 1 and 2 o'clock.
And that was on the 3rd of February?
Yes,
Did you see Dan?
I did. When I
Can you describe his mannerism?
described his what,
His mannerism?
he was very upset, and White was there.
Okay.
And so at first I was hugging and crying.
Objection, no response.
Well, overruled, it's not your witness, so it's not your objection to make. Nonetheless, counsel, you can't just testify in the narrative form, so I'll ask you to ask questions of the witness.
Later on, were you aware of a memorial down in Kootenai for Kendy?
Yes,
Did you have any discussions with Dan about attending that
I
memorial?
did.
What did you tell Dan about that memorial?
Objection, hearsay.
It's his statement, Your Honor.
But it's not a court statement offered for the truth of the matter asserted, so that's hearsay.
What he told Dan?
Correct?
Okay. Did you want Dan to attend the funeral?
Objection,
No,
relevance.
Overruled.
Why?
Objection,
There-
relevance.
The state's made it an issue.
Overruled. Overruled the objection.
there were threats that were rumored and
Objection,
going on
defamation,
Facebook.
calls for speculation. We're talking about rumors at this point, Judge.
I will sustain that objection.
So, you didn't want him to go?
Objection, leading.
Overruled.
I told Dan, don't go with it. It is not worth the confrontation. He wanted to go very bad.
Judge, I'm going to object again to the narrative form of the answer.
Understood. Mr. Howard, I need you to wait until Mr. Johnson asks you a question. Just answer that question alone.
Yes, sir.
Okay, thank you.
I don't have any further questions, but I'm sure this gentleman does.
Okay.
Thank you, Mr. Johnson. Any cross-examination?
Thank you, Judge. You described your son's general demeanor as very exacting. Remember that?
What?
That your son's general demeanor was very exacting. Do you remember that?
Yes.
In other words, he wanted things done his way, right?
No, that's not necessarily so.
Your son was very clear about how he wanted things done in life, right?
No, that's not necessarily so. He's just a forthright person that doesn't act. He didn't operate in a helter-skelter way.
He planned ahead, didn't he?
He what?
He planned ahead when he wanted to accomplish something, didn't he?
If he had a project, sometimes he would do that. Yes.
And you told us he would go through and finish those projects, wouldn't he?
The what?
He would finish the projects that he wanted to get done, wouldn't he?
Well, yes. I didn't live there, but the few that I saw him work on, like the boat or the projects with the animals on the place, he'd finish those.
Once your son had a goal in mind, he would see it through, right?
I would expect that.
He was that kind of man, right?
Like I said, I didn't live there. I didn't see it all the time. The few times that I visit, I was pleased to see the shape the place was in.
And he would go forward with a plan and put it into effect, even if he didn't really want to go through the details of that plan, but he would do it to get to the end result, wouldn't he?
Calls for speculation.
Overruled.
Did he go through the details of the plan? He never did that with me, but
Okay. Your son had was quick to anger, wasn't he?
he was what?
He was quick to anger, right?
I don't really know that.
Well, he was your son for a great many years, correct?
Did he what?
He was your son, he's your son, and he's been your son for many years, right?
Yeah, he accomplished many things on his place. It was a nice place and
But your son is quick to anger, right?
quick at what?
Quick to get angry. He's quick
I-
to lose his temper,
No, I don't
right?
think that. I never thought that.
He was quick to tell Kendy what to do and how to do it, right?
I never witnessed that.
You knew that Kendy wanted a divorce, right?
Dan had told me that they were getting a divorce.
Dan didn't want to get a divorce, did he?
What, I don't know. When I heard about it, I was told that they had both agreed to it and were making a list.
Dan likes his money, doesn't he?
What?
Dan likes his money, doesn't he?
I've never asked him about that.
But you've known him quite some time, right?
His normal what?
You've known your son his entire life, right?
No,
Besides liking his money, Dan also likes his property, right?
you're telling me how I view my son? I don't view him like that anyway.
Does Dan like his material possessions?
Does he like his what?
Material possessions.
I couldn't say that.
Okay. Dan didn't want to lose half his possessions to Kendy, did he?
Objection calls for speculation. If he
I,
knows.
that would be something I know nothing about.
So in terms of hearing, you told us that Dan can't hear out of one ear, right?
He can't what?
Hear out of one ear, right?
That's correct.
But he can hear out of the other ear?
Yes,
Okay, so you can talk to Dan and he can hear what you have to say, right?
yes. I usually make sure I'm close enough so we don't have a problem. He hears me quite well.
Dan can hear loud noises, right?
I would think.
Dan knows what the sound of a gunshot is like, right?
I would think.
And Dan can recognize the sound of a gunshot even though he doesn't have hearing in one ear, correct?
Well, I guess that would depend how far away the gunshot is and which side he's turned to it.
So the closer the better. Would that be accurate?
It's what?
The closer the shot was, the more he could hear it?
It would be to me, the closer it was, the louder it would be. I think that's with anybody.
No further questions.
Thank you. Redirect, Mr. Johnson.
Did you teach your son how to be responsible with money?
He was always responsible with money. If you look at their place, both of them were good savers. They got their animals together. They're both really responsible.
And the projects you were referring to earlier, you're referring to projects on their property, correct?
That's correct. They had animals.
It was leading, but I'm gonna let the answer stand, so, but I'll advise counsel not to do leading.
Thank you. Which ear is the ear that Dan has problems with?
His left ear.
Okay. I have one for question.
Thank you, sir. Thank you. You can step down.
Thank you.
Next witness.
Call Brett Gunderson, Your Honor.
Good afternoon, sir. Have you step forward, please? If you would face my clerk and raise your right hand and be sworn.
Do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. If you'd have a seat there for witness stand.
Thank you, Your Honor.
As best you can, speak to the microphone.
Good afternoon.
Good afternoon.
Can you please state your name and spell your last name for the record?
My name is Brett Gunderson, Gunderson.
Where do you live?
I live on Wheat Ridge Road in Athol.
Okay. Neighbors of?
Neighbors of Dan.
Okay.
Of the Howards.
What do you do for work?
Currently I work for the Forest Service.
Before that?
I joined the Navy in 1987. I worked on nuclear weapons for a while, got my clearance. And then in 94, I applied for the police academy, the military police academy, went to the military police academy. In 2001, I was commissioned as a naval officer, and then with a law enforcement designator, and I retired in 2011. Worked for the DOD for a while, and now I work for the Forest Service.
How long have you been Dan's neighbor?
I moved in, I believe it was February of 2014.
Do you know Kendy Howard?
I did.
Now, explain your interactions with Dan and Kendy prior to February 2021.
Well, I moved there when I first moved there. I just retired from the military not too far before that.
Objection to the narrative form of the answer.
I'll sustain, and if you could, turn the focus of your question.
What kind of things how would you interact with Dan and Kendy?
We'd have bonfires. We'd go on motorcycle rides together. He taught me a lot about, like when I first got there, I didn't know how to raise pigs. First thing he did was offer me a piglet, but I had nothing. I had no buildings or any way to do it. He came over and taught me how to build the buildings and how to raise them, and I mean, help him. I did sheep, and he kind of helped me with some of those things.
Okay. You know Carrie Maitland?
Yes, I do. She's my girlfriend.
You have a couple here?
I do. Yes, I do. She's my neighbor.
Okay. And she's also your girlfriend?
And my girlfriend is.
Was she your girlfriend at the time of February 2021?
Yes, she was.
And did you guys do things together as a couple with the Howards?
Yes, we did. We went on motorcycle rides together, and like I said, we did. We would have cookouts, bonfires at their house. My house, we'd watch sporting events, stuff like that.
How often or frequently would the barbecues be?
With the what? Excuse me?
Barbecues?
What was known as a barbecue, it could be just a bonfire. I would hate to try to guess the frequency, but mostly in the summer, obviously, and I don't know, at least maybe once a month.
Who all would attend these bonfires?
Wyatt, Dan's son, my girlfriend and I, and then Dan, Kendy, and then some of their friends, sometimes my friends from up north in Naples. And there was a lot of people that I didn't know that were Dan's friends.
You ever see, do you know who Dean Lampert is?
I know the name. I think I maybe met him once, twice at the most.
Okay. Do you ever see him there?
I believe I saw him there. That's where I would have met him. That would have been the only place I would see him.
Was there a typical, or how these bonfires normally end?
Usually ends, seeing as how there's a gate going to my property through Dan's property. I'd be there. We'd help clean up or whatever, and put out the fire, and we'd go home. We'd usually the last couple of people to go home.
Okay. A couple people being you and Carrie?
Carrie and I, yes.
Okay. Now, in the summer of 2020, did you ever observe the Howards getting ready for any sort of trip?
Yes, it was shortly after I had my shoulder surgery, and I'd re-injured it. We were driving to go to dinner, go get some food. It was like any other time. We drive by if the Howards were out and about. We'd stop and say hi, and just kind of the neighborly thing to do. And we stopped, I believe it was on July 10th, and we stopped, and they were loading up, getting ready to go camping. It's some lake with a weird name. I've never been down there. My arm was hung up. I couldn't have gone anyways.
Let me be clear here. Was there, without telling what it was there any sort of incident involving Kennedy or Kendy on that day?
Yes, we stopped to help. We stopped just to talk to them and say hey, and they were
okay.
They had their camper.
Yeah,
what they do?
I'm going to ask some follow-up questions.
Oh, sorry.
Yeah, just make sure we don't want to go into narrative. So
okay.
How are you sure about that date?
Well, I had my shoulder reattached, my bicep reattached in the bone, and it came loose. And I had a meeting that following Monday with my doctor, and I couldn't go on the camping trip. I was laid up, and I stopped by, and that's it. I don't know what you want me to say there. I mean, that's.
So, we had a prior hearing earlier. When did you learn, or did you do any steps to kind of narrow in this
Yes.
date?
Judge, I'm going to object to counsel's testimony and built into the first part of his question. Can you strike that?
Sustain.
How did you come upon that, or when did you come upon that date?
The date that I went in to see my doctors on Monday, the 13th of July.
Yes.
Several weeks ago, I knew that I was going to have to. I knew that I had hurt my arm. I wasn't sure of exactly what the dates were, so I called my doctors and re-verified that I had had when my surgery was, when my follow-up, when my bicep released, and then when they did the surgery to reattach my bicep.
What happened of note while you guys were there on that date?
I was helping Dan with my one arm. I think I handed him a couple of fishing poles or something. And Kendy and my girlfriend were up at the forward end of the boat. I was on the right side of the boat in the middle, and I heard her, I guess you could say heard her fall, but I heard her curse when she fell. And then I looked over, my girlfriend was standing there, and she stood up, and she'd fallen and hit the trolling motor, apparently, that was right there in the front of the boat.
Have you ever been asked by law enforcement about this event in the summer of 2020?
No, the first time anything was when we testified the last time. Law enforcement never contacted me ever anything about this incident.
In the 3 years?
Yes, yes, sir.
Now, is it fair to say, well, let me back. How did you learn of Kendy's passing?
Oh, wow. I don't, I would imagine it would have been from Dan. I don't.
I'm
I
not
remember
objecting.
we were driving.
He obviously doesn't know how he learned.
We were,
Hang on just a second.
sorry.
Based on the answer, it's speculative, so I'll sustain the objection.
How would you describe Kendy and Dan's demeanors when they were together, when you spent time together?
Well, they'd been married for, I think, over 25 years, and they got along fine. I didn't see anything out of the regular. They had fun together. We all enjoyed going out and enjoying events, and they had a good marriage as far as I'm concerned.
Did you have opportunity to talk to Dan after Kendy passed?
Yes, I did.
How would you describe his demeanor?
He was distraught. He was broken. Dan's not the type that usually wears his emotions on his sleeve, and I've seen him tear up a few times, and he's devastated.
Thank you. I don't have any further questions. Good Council Mike.
Thank you. Cross-examination?
Didn't you go through a divorce, like 2018 or so?
I did.
And that was, what, high conflict divorce?
After 32 years, I don't know there was high conflict, no.
Didn't you learn some lessons from your divorce?
Objection, Orders? Response?
I can move on with the next question. I think it'll become relevant.
All right. You move on.
Didn't the lessons you learned from your divorce lead to you giving Dan hints
Objection,
about
Your
what
Honor.
he should
Objection,
do?
Your Honor.
We approach.
Sure. The objection's overruled. You ready to?
Can you repeat the question, please?
Certainly. Did you give Dan pointers about what he should do in his divorce from Kendy based upon your own bad experiences?
If you're talking about in jest, I talked to him about it, and I said it's better to agree on things and not have to go through. I forget what it's called. You pay somebody, and you sit in two different rooms, and you agree and disagree on different things. Sorry, I can't remember what the name of it was, but you would come to agreements that way. And I was saying that I would have much rather come to agreements with my now ex-wife, and agree to everything without having to have the courts so much involved. So when you go to the court, everything's already agreed to, and then you move forward from there.
Dan and Kendy had a number of high-dollar personal property items, right?
I believe so, yes.
They had a camper,
They did have a camper.
they had a boat,
Yes,
they had a tractor,
yes,
they had a motorcycle.
yes.
And these are things that you advised Dan that he should sell them to you cheap so they wouldn't be part of the divorce split, correct?
Was that said? Yes, that was said in jest.
So you did tell Dan that?
It was in jest, yes.
You told Dan to sell the camper to you cheap so Kenny wouldn't get half of it, right?
In jest, I stated, you can always say that. You can always sell me your stuff for cheap. I even, because it was in jest, it was brought up to my girlfriend, and supposedly Kendy responded back to her, but it was in jest. There's no, it would have been illegal.
You told Dan to sell you his motorcycle so Kenny would not get half of it, right?
No, I did not.
You told Dan to sell the camper so Kenny wouldn't get half of it, right?
No, sir, I did not. I did not mention any specific thing. It was in jest. It was surely in jest.
So you were referring to all of their personal property when you made this joke, is that it?
It was in jest, and there was nothing specifically identified.
What were you referring to if it wasn't the personal property?
It was in jest. I wasn't referring to, I was referring to what I had gone through, and somebody else had said that to me, and looking back now, sure, I shouldn't have said it even in jest.
Dan is your friend, right?
Yes.
And that's why you made the offer to him, correct?
Again, it was in jest. It wasn't an offer. It was, we were speaking about the whole process. I'd been married for 32 years. I had a significant amount of stuff, and somebody had mentioned it to me. Hey, they knew somebody that sold the stuff for $500. So in jest, I said that to Dan, and that was it. It was not serious. It was not meant as anything real, and there was nothing identified, or even, I didn't even think about any of his property.
You and Dan have gotten a lot closer since Kenny's died, haven't you?
Yes.
You spend more time with him now?
As a neighbor, yes.
He's your close friend now, isn't he?
He is a friend, yes.
He's your close friend now.
Yes, he's a
isn't
close
he?
friend, yes, sir.
So back to this July 2010 incident that you remember because you hurt your shoulder. And it sounds like you went back and refreshed your memory with some medical documentation. Is that what you're telling us?
Well, I knew it was in June, July, or August, I believe. I knew that my arm was, I was having my issue with my arm, and I'd had my surgery. And so it had to be during that time frame, so all I did was recheck with my doctors when the dates were, when I had my surgery. They didn't have the date when my bicep popped out, but they had the 13th when I went in to get it checked out, and then they had me, I went back into surgery, because it's a VA, it took 8 days for me to get back in. But 8 days later, I had to reattach my bicep.
And that gave you the date of July 10th,
That gave me
2020?
That gave me the time frame of when my arm was hurt, and that I couldn't do a whole lot. I couldn't go camping. I couldn't do a lot of these things. And I know that's when this was that this happened, and I looked it up in the dates, and yes, that's.
And this was at the request of Mr. Johnson?
No.
This was at the request of whom?
It was on my own. It was.
Why were you doing this?
Because I knew I needed to know my dates. I don't want to get up here and perjure myself by giving the wrong dates.
Why did you need to know your dates?
Because it was, again, when my arm was hurt during that summer, was when when all this stuff happened. There's a lot of other things that happened that summer. But during this portion of it, that's when this happened.
And why is July 10th of 2020 important? Why did you need to remember it?
It's my mother's birthday, and on the 13th was the day that I went in. I had pulled, my bicep had detached from the bone and was running along the side of my arm.
I get that, but why are you testifying about that in Dan Howard's trial?
Because you asked me.
No.
What
This was
date?
brought up by Mr. Johnson. Why? Why are we talking about that?
Because it happened around the time frame that Kendy fell and hit her chest on the trolling motor.
Okay, so this is a attempt on your part to show how she got some injuries back in July 2020? Is that accurate?
I'm not.
Your Honor, let's get a position. You didn't ask the questions.
It's a fair question.
I'm not attempting to do anything. The prosecution ordered me to come here to testify. I'm here to testify to the truth of what I saw and what happened, and that's it.
You understand you're testifying for your friend, Dan Howard. Do you understand that?
No, I understand. I understand that I was asked to come here by the prosecution. I was told. I wasn't asked. I was told to be here today by the prosecution and to come here, and I'm here to testify to the truth of what I've seen, what I've heard, and what I've been asked. I'm not testifying for either side.
It sounds like you're familiar with the Howard's boat back in 2020. You've seen it before.
Yes, I've seen it before.
All right. I've got what I marked as 92. It's a photograph of the boat that was taken off of Kendy's phone. Take a look at that. Tell me if you recognize it.
That appears to be it. I don't know his. I did never memorize his the numbers off the boat or anything, but to the best of my recollection, it is.
Any objection?
Going to publish the same?
It's admitted and may publish. Sir, I don't know how well you can see from the side there. If you need to step out to look at it, you're welcome to.
It's the same picture I saw you on. Oh, yes.
All right, so can you show us where the trolling motor is? Would you like a pointer? So you don't have to walk up there?
How would you like me to do it?
Well, whatever's easiest for you. You can either walk up there or...
Control motor, use this right here.
And so you talked about Kendy. Well, let me get this straight. Did you see Kendy fall or didn't you see Kendy fall?
I was standing, I did not see her chest hit the control motor.
Okay. Let me ask it again. Did you see Kendy fall or not?
I saw her head go down
Okay. Where did you see her head go down?
at the front of the boat.
Okay. Where were you when you saw her head go down?
Yeah, right.
Yes, please.
I was standing over on this side. I was standing over this side, caught in the middle of the boat. And to my recollection, I handed up a couple of fishing poles a day and we were standing inside the boat. Carrie and Kendy were up here somewhere, heard the motion. It was like same time I looked, head went down, came back up, there was a curse.
What do you mean they were up there somewhere?
Well, my girlfriend and Kendy were up forward, apparently putting stuff up in the front of the boat.
So-
I wasn't watching them, I was helping Dan.
So you couldn't see them?
Out of my periphery, yeah, I wasn't watching them, yes.
Okay. Could you see them or not?
I could see them out of my peripheral, that they were doing something as I was handing up stuff to Dan, and then saw the motion, and then looked, there was cursing, and then they got up, and it was like, hey,
Okay,
I just
so
hit,
let's
I
just
hit
break-
the motor.
Let's break this down a little. So you're back by the wheels. Okay,
Yes,
great.
approximately about in the middle of the
And
two.
you're facing Dan.
Yes,
And then up by the trolling motor are the two women.
affirmative, yes.
But you're not looking their way. You're facing a different way. Is that accurate?
I wouldn't say I'm facing, I would say I was more quartering, I was handing Dan stuff. I mean, you always watch stuff in your peripheral, I mean, that's,
When you,
I didn't see it directly, if that's what you're asking.
let me figure that out, okay? So when you were handing Dan things, were you looking at what you were handing him?
No, because it was in my hand, I was looking up and handing,
Were you looking in the direction of Dan and the things that you were handing to him when whatever happened?
I would imagine yes.
You don't remember?
I remember handing him stuff
Okay.
and looking up at him, and then, I'm looking up at him, and just like I'm looking up at this, I can still see it. And out of the peripheral, there was a commotion, and then it was ouch. I just hit my blah, 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 and whatever, and then we were there, and then they were done
Okay, so
for the day.
you
and-
heard an ouch.
You know,
Where did the ouch come from?
I heard Kendy say something about something to the effect of like a curse word or something, and then I think my girlfriend went over there to her, and I probably just grabbed another handful of poles or whatever, and handed them to Dan. I don't.
Did you hear an ouch or not? You told us you heard an ouch first of all, then you said you heard a curse word. Was it both or either one?
I believe it was both. I heard
Okay.
an ouch and a curse word.
So you never saw anything, you just heard something.
Out of the peripheral of my vision, I could see going down, coming up, and then the cursing as I was handing poles off this way. I could see out of my peripheral.
Going down what? What was going down?
Her head. Her head going down
Going down where?
at the front of the boat.
Okay, so you told us she was at the front of the boat on her feet. What happened to her?
I don't know. I don't know exactly what she was standing on.
How do you know she went down?
Because out of my peripheral, I saw movement, and then I heard whatever it was that I heard, ouch, and the F word or whatever it was, and then we went on from there.
How do you know she just didn't dip her head?
Because of the follow-on curse words that I heard, that she didn't just dip her head.
So you never saw her fall down, you just saw her head dip. Is that accurate?
It is accurate to say that I did not physically see her body hit the front of the boat.
Okay, did you see her fall down or not?
Yes, out of my peripheral, I saw movement out of the right side, or dip down, and then come back up, cursing, saying, just in front of the boat, and then, I mean, it was almost 3 years ago. I don't remember all the words and everything that was said.
Okay, so she dipped down and what part of her body hit what? Could you see
I
that?
couldn't see that part.
Okay, so you don't know what she hit or what part of her body hit, whatever it is she hit. Is that accurate?
It's accurate, that she was up in front of the boat, and then she dipped down, hit something, came back up, and ouch, something to that effect in the first word.
Well, when you started us out here, you said that your girlfriend and Kendy were at the front of the boat. Are you talking about in the boat?
No,
Okay, they were on the ground.
or standing on somewhere on the trailer.
There's a big difference there. Do you know which one it was?
I believe they were standing on the trailer. I believe my girlfriend was standing, or she could have been standing on the trailer. Again, it was out of my peripheral. I'm halfway down the boat. So my view of what they could be standing on, I would have to stand there on that boat and look again to see if I could see their feet. I don't remember anything about the feet or whose feet were where.
Well, it sounds like you don't know where they were standing. Is that accurate?
Specifically, no, I don't know where.
You don't know if they're on the ground or on the trailer, right?
From my vantage view, yes.
And you don't know what Kendy hit, if she hit anything, or what part of her body hit, if it hit anything. Is that accurate?
Yes, that is accurate, but there was the boat motor up there was the only thing that was logical. She hit the boat motor or the front of the boat. I don't know. She hit something and then she came back up again.
How
Is
did
that
she
not-
hit the boat motor if she was on her feet in front of the boat?
Well, she was elevated. If she was standing on the ground, I wouldn't be able to see her. So she had to be standing on something. She could have a step ladder. She could have been standing on the frame of the trailer. That I'm saying that I can't. I didn't see that far. That I don't know. I don't know what. I know the trailer, the camper was there. They loaded the camper. They're just stopping by and say hi and helping me load the trailer. And that's.
Well, this whole stepladder business, did you see a stepladder?
No, I didn't.
Where did you come up with a stepladder?
I'm just saying I don't know what she was standing on. Is what I'm saying.
Well, then, if you don't know what she was standing on, how do you know what she hit?
Because of where she was located on the boat. Because she was all the way up at the very front of the boat. If I had, well, I'm not gonna guess, where it was. I would assume that she was standing.
You can't assume, sir. You have to tell us what
There.
you saw, okay?
Yes,
You
sir.
have to tell us what you saw, okay?
Yes, sir.
All right. And it sounds like you didn't see anything, did you?
I had my proof. Her head come down. And her fall.
Well, he answered questions. Overrule the objection.
You don't know whether she injured herself or not, do you?
She always bruised really easy. She got some bruise.
Did you hear the question, sir?
Say,
You don't know whether she injured herself or not, do you?
I know she ended up with a bruise from that. Because she talked about it with my girlfriend, and they went on a trip, and she was.
Do you not understand the question, sir? You didn't see her injure herself, did you?
I'm guessing.
You can't
the answer to
guess.
that is that I can't say that I definitely saw her injure herself.
Well, you just got done telling us you didn't see anything. Do you remember that?
No, I didn't say I didn't see anything.
You saw her head dip.
I saw that she was elevated. I could see the top of her. She was my girlfriend. She was meeting her. I was on the side of the boat. She went down. There was an ouch or something to that effect, some cursing, and then she like, ow, that hurt. And then we went on. I don't remember what else was said after that.
I think you can take your seat again, sir.
Thank you.
No further questions?
Thank you, Reader.
Council will ask you a lot of rapid fire questions. You saw something,
Yes, I did.
and well, let me back up. Did you, in answering council's questions, did you have try to interject a script or a narrative that you previously had worked out?
No. No.
Okay. So he's asking a lot of questions, but you saw something.
Yes.
Did you hear something?
Objection. I'm leading 2 times in a row now.
The second one wasn't leading.
I'll overrule the last question was okay.
Did you hear something?
Yes.
What was that?
I heard something to the effect of ouch and a curse word, and it wasn't a boom, but there was a loud, I guess not a loud, but a noise up front, a disturbance up front with where my girlfriend and Kendy were at.
How tall would you say Kendy was?
No, I would guess she was 5'3", 5'4". I don't know.
If you were to stand up, how tall would she be compared to you? Do you think?
I believe she was about here.
Okay. And so what you saw, would it be consistent with her standing on the ground or not?
I don't believe I could have seen her if she was standing on the ground, and that's why.
And there was no lying on the ground in agony.
Objection.
Or, I'll rephrase. The council asked you about the date. You remember that?
Yes.
And how you know the date?
Yes.
Did you have to go through rapid fire questions in a previous hearing before?
Yes.
And did some of those questions involve how you know the date?
Yes.
Did where did you have surgery?
I had the surgery. Of course, you're going to ask me that question. It was in Post Falls.
Which place?
Oh, my doctor's name was Greg, and it was orthopedic and physical security. It's right there in Ironwood. It's an OPMI or something like that. I can see the sign. The VA, the VA. It's whoever the VA sends you to, and that's who I got. So I didn't search them out, or that's just who the VA sent me to for the surgery.
You referred?
Referred, yes, sir.
And you said it was Dr. Gray?
Greg. His first name was Greg. I don't remember his last name. He was.
And is that why you took it upon yourself to kind of narrow in when that happened?
Yes, because I'd been asked questions before, and I didn't know when it was. I knew my arm was hurt. I knew I just pulled my bicep, and so that's when I contacted the doctors, and I'm like, hey, when were these dates exactly? And then that is what nailed it down to, for my memory, exactly what day it was.
Okay. I don't know.
Judge, may I ask a couple of additional cross questions pertaining to this hearing? Mr. Johnson brought up on the,
I'll allow it to be sent, that was new information.
thank you, Judge. Counsel, I'm going to approach with his hearing testimony on page 11, lines 1 and 2.
Next.
Excuse me, it's page 12, lines 1 and 2. So I just want to ask you some specific questions about that hearing we testified to before, okay?
Yes, sir.
Since that issue came up. And I'd like to direct your attention here to page 12, line 1. Line 1, Mr. Johnson is asking you some questions. Is that accurate?
By Mr. Johnson,
By Mr. Johnson.
did you see her fall? Yes.
Yes. So then he asked you on line 2, did you see her fall? What did you say there on line 3?
May I move it so I can read it? Did you see Mr. Ron get into an altercation at that time? And it says no. Oh, I did not physically see her fall.
And what question were you answering from Mr. Johnson?
So did you see her fall? I did not physically see her fall. So the contact with the chest, I did not physically see that.
Thank you. No further questions.
You right on that?
But you did see your head move.
Objection, meeting.
What did you see?
I did see that there was commotion up front, and then her head went down, came back up, there was cursing, and then we went on from there.
Thank you. No further questions.
Thank you, sir. You can step down.
Thank you, Your Honor.
Sorry, I could have already took that. We're going to take about a 10-minute afternoon break. We'll be in recess. Please rise for the jury. We'll be in recess. may be seated. Next witness, Mr. President.
Your Honor, defense calls Ms. Carrie Maitland.
Good afternoon, ma'am. Could you please come forward? If you face my clerk, raise your right hand, please for me.
Do you solemnly swear that the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, ma'am. You can have a seat by the witness stand. And as best you can, if you seat in the room. You may depart.
Good afternoon. Can you please state your name and spell your last name for the record?
My name is Carrie Maitland, M-A-I-T-L-A-N-D.
And where do you live?
I live on Wheat Ridge Road, neighbor family Kendy's for 20 years.
And do you know Brett Gunderson?
I do know Brett.
How do you know him?
He's my good friend.
Okay, do you guys live in the same house?
We do not. We live across the street from each other.
Okay. What do you do for work?
I am a certified medical coder for 13 years.
And you work from home?
I do work from home.
Okay. And so how long have you known, or have you known Dan and did you know Kendy?
Yes, I've been working with them for 20 years. Our kids hung out together.
Okay. So prior to you moving to that area?
Prior to that, moving up there, no, I did not know them. We moved in about the same time.
Okay. Did you have many interactions with the family?
Yes, many.
Can you explain in general what kind of types of interactions you had?
But they would have barbecues and we would go over, or the boys would hang out together, so I would have Wyatt over at my house, or Nicholas would go over with the Howards. He went camping with them, went fishing with Grandpa Howard and all of them. I watched Kendy's granddaughter Kenley when Dan was up on the slope. I would make sure Kenley made it to the bus stop, and then I'd pick her up from the bus stop on those days, and so Kendy or Brooke would pick her up. I interacted with Kendy a lot. We communicated most often personally.
Okay. Okay.
She ordered bath bombs from me and that kind of thing. So.
When, before she passed, would you say that you were closer to Dan or Kendy?
I was closer to Kendy.
How would you describe your friendship?
We were fairly close. Kendy would come over and we would hang out periodically, and many times we would have a beer, or we would just sit on the front porch and watch. I have a daughter that's 10 years younger than Wyatt, so we'd watch a movie play in the front yard and that kind of thing. We're just friends.
Okay. And did you say that, what was the primary form of your communication?
Most of our communication was one-on-one. We'd see each other. She'd be out in the driveway, I would stop by, or we'd run into each other at the mailbox. A lot of the time is when we ran into each other.
Did you ever stop over unannounced at their house?
Yes.
What kind of scenarios?
If I saw them out in the yard, I would just swing in, or if I had Amelia in the wagon, I would come in, or they had this little pug dog that liked to escape, and so I would take the little pug back to the house, and sometimes they wouldn't even be home, and I'd put the little dog back in the little cage that we had in the brush for it.
Okay. So back in the summer of 2020, did you ever see Dan and Kendy in their shop area?
Yes.
And can you explain?
They would be out in the yard, or out doing things. Summertime. Kendy sometimes would be offloading something out of her car, or groceries, or whatever. And so if we were driving by, we'd stop if I was with Brett, or we'd stop individually. So.
Now, is this road you live on? Is this a dead end road or a
It's a
road?
private road with a cul-de-sac at the end. Yes.
And how many residents live in that?
There's 9 homes.
Okay. In the summer of 2020, was there anything that you observed that involved a boat?
Yes.
Can you explain?
Brett and I were headed out. We saw the camper and the boat out, and them out as well. And so we swung in really quick, just like neighbors do. And we pulled in, we got out. Kendy she had a basket or crate or whatever, I can't even describe it, and put it up into the camper and slammed the camper door shut. She was kind of in a, can I say, pissy mood? She wasn't exactly happy, so I was like, hey, what you doing? And just, trying to distract her a little bit that way. And she had something down here on the ground, and she had something up here on the boat, on the front of the boat. Brett went back, of course, and talked to Dan, because that's what we did. We divided, male, female. And when we went our separate ways, I was kind of standing towards the front of the boat with Kendy right there. And she was, like I said, she was grumpy, and she was at the front of the boat, and she was reaching out with this. It wasn't a large thing, but it was just reaching out with it, and she slipped, and she fell down, like boom, like that. There's a lot of foul language that was involved, like, oh, that hurt, those kind of things. And I was like, oh my God, Kenny, are you okay? And then she's like, yeah, I'm fine. And that was kind of the end of it.
Were you ever asked by law enforcement about that event?
No.
Did you ever spend time with just you and Kendy?
Yes.
Okay. Now, is there an experience that stands out that's significant sometime in the fall involving you and Kendy?
Yes, sir.
Objection to relevance, and I think a specific instance of conduct would not be permissible at this point.
May we approach this?
Okay. You can see it. We were talking at the bench here, and Mr. Johnson, you indicated you were intending to ask about an incident in which the witness was concerned about Ms. Howard's harming himself. Is that right?
Yes, Your Honor. And I won't say that what it is right now with her on the stand, but there is a specific incident, not a vague observation, but a specific incident where, again, I don't want to get too much detail, but where there was concern revolving one of the key elements that Dr. Hanger testified about previously and is relevant in this case, and directly addresses some other testimony put on by the state regarding demeanor and of Ms. Howard. And so I think it's directly related to what the state has presented. It is close in time, and it is her personal knowledge of this incident, obviously subject to cross.
Judge, my suggestion would be that counsel put on an offer of proof through questioning of this witness, so we know exactly what it is she's going to say. That way, I think the court can make an informed decision about whether or not to admit this evidence.
Are you all right with that, Mr. Johnson?
I can, Your Honor. Sure.
Okay, go ahead.
So, Ms. Maitland, you said there was a specific incident. What month did you say it was?
It was the end of September, 1st of October. I don't know the exact date.
Okay. Can you describe that incident?
Yes. Kendy came over to the house, and we were talking. We were out on the deck. We'd had a couple drinks, and she was super excited about getting this costume for this costume party down in County Line. And as the conversation went along, that's when she admitted to her relationship with someone else. And I proceeded to say to her, you can't do this again. You need to make a choice between this person and your life, and you can't do it to your kids. And it got to be a very emotional conversation between the two of us. We brought up several things. We talked about how after the incident at Dan's work, he changed a little bit, and how she felt like she was abandoned, and she got very emotional, and I use a term called broken. And it escalated, and it continued to be very heated. It went from anger to sadness to just watching someone kind of fall apart in front of you. And we proceeded to drink, of course. It's like, hey, we hugged. We were friends. And Kenny confided in me, and what Kenny told me stayed with me, and she knew it. This wasn't the first time she confided in me. And I just told her, you can't. You gotta make a decision. You can't do this. I'm like, if it's just about the money, then just take out $100 every time you get groceries so that you have something so that you can move forward. If that's all it is, if you actually love Dan and you want to stay with him, then you stay with him. We can't do this again. You just can't. And it proceeded that way, and she was very upset. And like I said, she went high, angry, low, and finally it was like, Kenny, I gotta take you home. You're shitty drunk.
we're not getting anywhere here, you know, and I knew she had to work. So I took her home, and when I took her home, I was afraid for her. I was seriously freaking afraid for her. I'm sorry. And I told her, I said, Kendy, where's your gun? I looked through all the drawers in the room, and she says it's in the safe. And I said, okay, I'm gonna lay with you. And I laid there, and I held her, and until she fell asleep. I went downstairs. I took all the kitchen knives and stuffed them in a Tupperware and threw them in the garage. I did not sleep that night. I went to her house every hour on the hour until it was time for her to get up and go to work. I begged her, please talk to someone. And she said she would. And my biggest regret is I never told anyone.
That's our offer proof.
Well, Judge, I'd move to exclude the entirety of this testimony. It has nothing to do with the prior attempt in terms of suicide from Kendy. It has to do with her speculative opinion that she was going to kill herself. And it's a very emotional opinion. It has no place being in front of the jury. The proper way in order to impeach the testimony of Dr. Hanger would be to ask whether or not this witness has an opinion in terms of her personal experience with her, whether she was depressed back then. And that would be set forth in IRE 608. 608 allows for this type of evidence to come in terms of an opinion from a witness that has some experience with the person that she's talking about. The rule also says that specific instances of conduct are not to be delved into on direct examination. And so essentially what we're doing is we're presenting opinion evidence in a fashion that the rules say we can't do it. And we're doing so based upon the speculative nature of this witness's feelings about what Kendy may or may not have been thinking. We're also doing this in an emotional fashion, and we're also bringing up the incident that occurred back in 2013. So, number one, this evidence is not being admitted pursuant to the rule. It's not being admitted properly to impeach Dr. Hanger's evidence. It's impermissibly emotional, and it's based on speculation from this witness about what Kendy thought she might do. Moreover, if the court were to review the testimony of her account of this in terms of the grand jury, it's completely different. That's on page 455. It goes forward from there. I don't know that that's really the point. Nonetheless, Judge, this type of evidence is impermissible pursuant to the rules. Thank you.
Any responses, Justice?
Well, first, on the grand jury, she tried to give other answers to the grand jury, and obviously was non-responsive because it wasn't an answer to a direct question. Secondly, again, law enforcement has never talked to this witness in the 3 years since her passing. Third, Dr. Hanger specifically said that prior acts of suicidation can increase one's susceptibility to suicide. We already have the foundation for one. It's not subject to this right here. Here's the foundation of another one. And I do not intend to elicit, I let her continue for an offer of proof. I do not intend on getting into the 2013 case with her at all. So that's not what I intend to do. But this is not speculation, I would argue. This is someone who's known her for 20 years, watched her kids grow up basically together, has an intimate relationship with her, very personal relationship, and lives across the street, sees her all the time. So it's more than just speculation, and it is an isolated incident that is, I think, should be allowed.
Well, having listened to the testimony, there was nothing from this witness that said Ms. Howard spoke of suicide or suicide ideation. I'm concerned about a couple things. One is she repeatedly said what she told Kendy, which is can't do this again, which suggests and puts another jury that this has happened before, which is not admissible as a subject of emotional living. Both parties agree that's not admissible. There's reference to what happened with Ian's work, which again, I don't think defense wants to get into. Both parties agree that's not admissible. What I do find admissible is, counsel for the state's correct, as a general rule, specific instances of conduct aren't necessarily admissible, but it's unique in this case because specific instances of conduct have been completely admissible for the state to prove conduct inconsistent with suicide. That's how come the state has been able to talk about so many things of specific conduct, the buying a home, the various things that she did inconsistent with suicide. And the flip side of that coin is that defense needs to present specific instances of conduct that they believe is consistent with suicide. And so, if your defense has a particular time, close enough in time to be relevant, and I find that it is, where this witness observed Ms. Howard's demeanor to be consistent with being depressed and potentially harming herself, I find that the defense is allowed to present that. But that's more limited than what this witness testified to. this witness's personal opinion of, I was afraid for her, and so I took all the knives, I stayed up all night, and so forth. That's just this witness's speculative opinion of fear for Ms. Howard. That's not relevant. How Ms. Howard behaved, however, is relevant, if you follow me on the distinction there. So all I need to question about this incident, but the witness needs to understand, she's not to refer to telling Ms. Howard we can't do this again. She's not to refer to Mr. Howard's work situation, and he lost his job and was charged, all those things. She's not to refer to that, and then just her own personal opinions of being worried for her. I don't find that that's appropriate when you give this foundation for that. But as a state court, she could ask if she thought she was impressed at that time, then she can ask about her demeanor and her emotional state, and to the extent it's relevant to showing that there may have been some intent to harm herself, that she was or just in a very emotionally depressed state. That's fair defense evidence. So if you want to take a minute and talk to your witness, I'll let you talk to her, because I don't want you to open doors in front of this jury that we've already determined should not.
With the court's permission, and I'll talk to the witness for a minute, but with the court's permission, it might be helpful to be allowed some leniency in leading a little bit. Read this just to avoid, not leading like suggesting, but just controlling a little bit.
Yeah, I would expect you to control the questioning quite tightly to keep this in mind. If you have to lead a little, that's okay, as long as it's not inappropriately.
Okay.
Let's just take like 3 minutes, and I'll let you talk with your witness privately.
All rise.
Let's bring the jury back in. You may see it. Thank you. All right, you may proceed, Mr. Johnson.
Thank you, Your Honor. So, Carrie, was there ever a time that Kendy discussed her affair with you?
Yes,
When was that?
that was end of September, first part of October.
And if you can go ahead and pull that mic a little bit closer. Can you say that again? When was it?
The end of September, first part of October.
Okay. Did she tell you who it was with?
She did not say a name. She just said that it was someone that she's known for a while.
And where did this conversation take place?
On my back deck.
What were you guys doing?
We were just drinking and talking, and she was excited about getting a costume for a Halloween party, and it led to her telling me about.
Can you describe in general her demeanor throughout the course of that conversation?
It started out jovial. We were just hanging out. We were being good friends. And then as the conversation proceeded, she became inconsolable. She got angry. And she was mad. And she was sad. And she was spiraling.
Did her demeanor cause you, let me rephrase that. Did you ever discuss your observations with anyone?
No.
Do you regret that?
Objection relevance as to what she might regret or not regret.
Sustained.
Carrie, how did you learn of Kendy's passing?
Brett had an appointment at the DMV, and we were leaving, and there was police cars.
Objection to the narrative form of the answer.
Overruled.
You can continue.
And the coroner's truck was there, and so I messaged her on Messenger, "Are you okay? I'm worried about you," and I didn't get any response. Brett also tried to contact Dan, and it was later.
Same objection.
Oh, I can ask another question.
All right. You direct another question. Overruled.
Did you have an opportunity to talk to Dan after Kendy's passing?
I did.
Can you describe his demeanor?
He was very solemn and withdrawn. When he would get emotional, he would walk away for a moment and collect himself before he would come back to the conversation that we were having. I had organized the dinners for him and Wyatt during that time with all the other neighbors. And he was gracious about that, but he was grieving.
I have no further questions for you.
Thank you. Cross-examination.
So this incident that you described at the end of September, early October, you didn't get us to a year. Was that 2018 that happened?
No, sir, that was 2020.
Did you ever tell anybody it was 2018?
No, sir.
Okay. You sure about that?
Yeah, I'm sure of that.
So it was 2020, September, October.
Yes.
Okay. So 5 months before she died,
That's 5-6 months, yes, sir.
and she got drunk,
Yes.
and she got upset.
Yes.
And I'll bet that's happened to you, hasn't it?
Did in November, yes, sir.
You've gotten drunk and you've gotten upset.
Yes, I did.
I bet that's happened to most people, hasn't it?
Objection, please.
Sustained.
This interaction you had with Kendy left you in tears today, right?
Left me in tears for a long time now.
In just a few questions from Mr. Johnson, you were crying about this incident that happened with Kendy, right?
Yes.
Yet you never told the police about it, right?
The police never talked to me, sir.
Do you know the number's 911?
Objection, argument.
Sustained.
Do you know how to call the police?
Objection, argument.
That's overruled.
In 2020, how many times did you talk to the police? 2022, how many times did you talk to the police?
I talked to the police regarding this?
No.
Or just personally?
How many times did you call and talk to the police in 2022?
Relevance.
I'll have a question just as it is.
Do you know how many times?
For personal reasons, I talked to the police twice.
You talked to the police on August 29th of 2022, right?
Objection, no. It's the same.
When you talked to the police, you didn't tell them about this incident that left you in tears in front of this jury, did you?
In 2022? No, sir, I
Right.
did not.
Okay. On August 29th, 2022, you didn't tell the police that?
No, I did not tell the police that.
You had the opportunity to, though, right?
Yeah, 2 years later, yes, sir, I guess I did.
Okay. But you chose not to tell them?
It was irrelevant to what the situation was, sir.
4 months later, in December, you called the police again, right?
Yes, sir.
And you had the opportunity then to tell them about this thing that left you in tears here this afternoon, right?
Yes, sir.
But you didn't do that, did you?
No, sir, because it had nothing to do with the situation that the call was about.
So back in September, October of 2020, you knew how to get a hold of the police, didn't you?
I did.
After Kendy died and this investigation was launched, you knew how to get a hold of the police, didn't you?
Yes, sir.
But you chose not to do that, right?
Yeah, I
And
suppose
you,
I did.
And you chose to do that today in front of this jury in tears, right?
Yes, sir.
Did you plan that out now?
No, sir.
It's the same.
In terms of this incident where you say you saw Kendy fall,
Yes, sir.
you remember what year that was?
2020.
I think you told us this.
Told you what?
Okay.
And Marcus, on 93, take a look at the location, the camper, the truck, the boat. Tell me if you recognize that.
Yes, I recognize that as Dan's truck and the boat with the camper on it.
Okay. And is that the truck, camper, and boat belonging to the Howards back in the summer of 2020?
I believe so. I can't see the boat well enough to say.
Okay. Well,
But
I'll
I know
show
the
you.
camper is.
I'll show you another photograph of that. Maybe I should just do it right here. Can I approach?
Yes.
Can I see 92? All right. So I realize you can't see the boat very well in 93. What about in 92? Close up there. Does that appear to be the boat?
Yes, it's the Ranger.
Okay. So it is the Howard's boat in 92?
In 92?
Yeah, the exhibit number.
Oh, yes, this is the boat.
Looking at 93, that's the next one. After using Exhibit 92, does the boat in Exhibit 93 appear to be the boat that they were towing that summer when you saw this incident?
It looks similar, yes.
Okay, and so can you tell us in 93, Exhibit 93, is that about the location where this happened?
No, sir, it was pulled over a little bit.
It was what?
It was pulled over from the shop. It wasn't straight out from the shop.
So
It
how
was
many
more towards the garage.
How many feet towards the garage did this happen?
Feet from the garage itself? I couldn't tell you that, sir.
Okay. Does the time frame look accurate?
I mean, it's summertime.
What's the time frame on Exhibit 93, ma'am?
The time frame says 7/15,
2020?
2020.
Does that appear to be an accurate timestamp for that photograph in this incident that you told us about?
I assume so, yes.
Move to admit 93?
Any objection? No. 93 is admitted.
Publish 93?
You may.
Okay, so we're looking at the truck, the camper, and the boat all hooked up.
Ma'am, if it helps you, if you need to step out to see the picture, you're welcome to, or you can see it from there.
I can see it. Thank you.
Is that right?
Yes.
Okay, and are we looking at their shop?
Yes, we're looking at
And
the
would the garage be more that way?
The garage is more south of there, yes.
Okay. But is that generally how it was hooked up that particular day when you saw what happened?
I do not remember if the truck was hooked up to the boat or not because Kendy was up in the camper when we arrived.
But you said something about her getting something out of the camper and then putting it in the boat, right?
No, I did not, sir.
Okay. Where did she get whatever she put into the boat from?
From the ground. I think they were cleaning stuff because she put the basket into the camper, shut the door, came over, grabbed. It was I don't even know what was in it, to be honest. I don't know if it was towels or what was in it. It wasn't heavy. The thing wasn't heavy.
Okay, so she did put something in the camper.
She did put something in the camper, shut the door.
But you don't remember if the camper and truck were hooked up to the boat?
I don't remember if they were hooked up or not because she came over, she came out of the camper, hey, and she was grumpy that day. And I was like, hey, what's going on? And so then we just proceeded on over. I didn't pay any attention. That to me meant nothing, whether it was hooked up or not.
But the rest of it did mean something?
Pardon?
But the rest of it did mean something?
The rest of what, sir?
What happened that day?
Her falling? actually, you know, after she said she was okay, it didn't really, you know, she said she was okay. I didn't ask her to show me the bruise. I didn't ask her to, you know, let me see if you're okay. You know, she's I'm fine. And that was the end of it.
We'll talk a little bit more about that in a minute. But I wanted to ask you about when it was that you went over to the house and saw this happen. Was it in the morning hours?
It was midday.
Okay, so we've got a time there of 7:43 a.m. on that.
Yes, sir.
Does that appear accurate or not?
I couldn't tell you what the day looked like at 7 o'clock in the morning 2-3 years ago. I'm sorry, sir.
Okay, but you're sure about the date, July 15th, or not?
That's what it says on there, yes.
What about your memory? Does July 15th of 2020 seem right to you?
I'm not understanding what you mean by
Well,
that.
the summer consists of several months, right?
Objection.
There's an objection.
Your Honor, counsel's trying to, may we approach?
Yes.
I'm not really sure what the question was, and I bet you don't remember what it was either.
Do anything different.
When they left to go on this camping trip?
Objection, mischaracterization of testimony.
I'll sustain that. That doesn't seem like that's what the witness was answering in terms of your question. So I'll sustain that.
Is that the date you saw them leave?
Sir, I never said I saw them leave.
Did they leave to go camping?
They did leave to go camping.
The same day you saw them load the boat?
No, sir.
Okay, so they loaded the boat. How long before they went camping?
They were cleaning the boat and the camper, so I can't tell you exactly how many days before. We were going through a situation with Brett. Brett had had surgery in June, and he had retorn it. And we, on the 13th of July, went to an appointment, and he had emergency surgery done 8 days later. So I can't tell you exactly when. I know that she mentioned that they were going on their door shack trip because they do that almost annually. Other than that, sir, I cannot tell you the day they left or any of those things.
Okay, was it before Brett going to the doctor or after?
It was before Brett went to the doctor.
When did Brett go to the doctor?
On the 13th of July.
Okay. And so this photo from the 15th of July, you think that's when they were already gone?
I don't know, sir.
Well, let me show you another photograph that's already been admitted. And the one that has a better picture of the boat. The one in front of me, too, okay?
Okay.
I'll put it on the armor for you.
Okay.
Can you describe for us where you and Kendy were when this incident happened?
Can I-
Using 92.
Can I
Yes,
point to
yes,
it?
please.
So, Kendy was up here in this area. I was standing at one where this kind of, I don't know if that's what maybe, right here. I was just off to the side of her, and we were just talking.
Where's
and
Brett?
She reached up, fell like this, right here.
Okay, so if you're by the buoy, where was Brett?
He was back at the back with Dan.
Where, can you show us?
He was back in here. He was like back towards the back end.
So he was by the back end motor?
He was back in the back there.
He wasn't by the wheels of the trailer?
Sir, I was not paying attention to where Brett was. I was talking to Kendy. I know that he walked back there. He was standing there. He handed down a pole. Other than that, not with his right hand. He did it with his left hand because his right hand was the one that had the surgery. Other than that, I wasn't paying attention to the guys. I was paying attention to what was going on here.
Okay.
So I apologize.
No, it's all right. I just want to ascertain where you think Brent was when this happened. You think he was,
Okay,
no,
sure.
just hang on and listen to my questions, okay?
Okay.
Do you think he was by the back motor, where you just indicated?
He was by the back
Objection,
corner,
calls for
back there.
factualization.
He was at the back of the boat. He was behind these two tires. He was back there. I don't know if he was standing by a motor. I don't know. I cannot tell you. I wasn't back there with him.
You just know he was back by
He
the...
was back behind
Let
me.
me finish answering the question. A court reporter's trying really hard to get the question and then the answer down, and we're both talking. It's impossible, okay? Okay, so he was by the back motor. Is that accurate?
I don't know if he's by the motor, sir. He was at the back of the boat. That's all I can tell you.
Okay. Do you know how you have the wheels of the trailer there?
Yes.
Those are in like the middle of the boat? right?
Middle to back end of it.
Was he by the wheels?
He was behind the second wheel. Yes.
And what was he doing?
I have no idea other than he handed down the pole when we got there. I don't know. He could have been holding Dan's hand back there. I was not paying attention to him. I was in my conversation with Kendy.
Okay. What do you mean he handed Dan a pole back there?
There was some fishing poles when we came up that were right there, same place where he was standing, and he handed down a pole.
So you watched him do that?
Yes, because that's as I approached, and then Kendy came out of the trailer.
Okay. So Kendy gets out of the trailer, and did you tell us the trailer? Do you mean the camper?
The camper, yes, sir.
What does she have?
What kind of camper?
No. What does she have in her hands when she came out of the camper?
Nothing. She shut the door of the camper.
And
She
then-
was done with the camper.
And then what happened?
And then she went, there were 2 or 3 things on the ground. She grabbed one of them, climbed.
Hang on. Let me just ask you.
Witness was answering his question.
Well, you can direct us with this.
I just want to take it in steps, okay? So where did she obtain this thing she picked up?
They were on the ground. I mean, this picture's not going to depict because the concrete was there. They had cleaning stuff out there. They had buckets out there. They had all sorts of stuff out there. She had some things, I don't want to say under the trailer here, but they were sitting right here. That's why I was back behind it. She grabbed the little container. She climbed up on it.
I couldn't hear what you said. She grabbed what?
A little container. I can't tell you what was in it.
What was in the container?
I don't know that.
That's answered.
Okay, hang on. I got some more questions for you, all right? So how big was this container?
It was, well, for me, and he's a little bigger than I am. For me, it would have been like, you would have been holding it like this.
And for the record, your hands are a couple feet apart?
Yeah.
Okay.
Cut in half, maybe. It was a little square container.
Was it open? Did it have an
There was
open?
no, yeah, there was no lid.
Okay, but you couldn't see what was inside it?
I didn't pay attention to what was
All right. And so where did she pick this up from?
right down the ground,
On the ground?
from the ground.
Okay, and then what happened?
Then she stepped over here, and she set it up here, tried not to get it on the edge of the boat.
Okay, hang on. So did she step on the trailer? Is that what you're pointing at?
Yes, she stepped on this step here,
Okay.
and then she stepped forward a little bit to brace herself on this thing. I don't know what this thing's called. So she had one foot on, one foot off, and she reached up there like this, and this foot down here, right here, where there's the little skitty pads, it slipped, and she came down. Left the container up there, stepped off, said some foul language, said, oh my God, are you okay?
Where did she fall to?
She fell right here on this.
What did she fall on?
She fell right here, in
Okay.
this area.
And you're
That's
pointing
the
to-
trolling motor that's right there,
Okay, hang on. So,
and the pedal.
okay, so you're pointing to the trolling motor at the bow of the boat, right?
Yes, she fell on the bow of the boat.
And she was lifting this container of whatever it was to the left of that motor, right?
She was right here, and she was lifting up, and she fell.
Okay.
And she caught herself on her arm, like you do when you're scared of falling. You grab out, and she caught herself.
So did she set the container to the left of the motor?
And they actually took over, so I couldn't tell you if it was on the left, right, or whatever.
Do you see how the trolling motor sticks up above the bow?
I see how it's.
And do you see how if she stood on the trailer, it would be natural for her to put it to the left of the trolling motor?
I assume.
Because the trolling motor is so high, and to put it over the trolling motor would be very difficult?
She wasn't over the trolling motor, sir. She fell on the trolling motor. She was reaching in, and she fell.
Where did she set what she had before she fell?
Set it, it fell.
Fell where?
It fell on this flat surface right here, because that's flat. It fell and tipped over. It was just a whole, it was quick.
Okay.
I don't know what you want me to tell you, sir, but it tipped over. I don't know what was in it. I asked her.
I just want you to answer the questions, okay?
Okay.
So when she put this container down and fell, or she fell and the container fell, it was to the left of the trolling motor, right?
I assume so, sir.
Well, you saw it happen, didn't you?
Yeah, I assume the basket ended up
We-
to the left of it. It was in the middle of the thing, so
Well-
I can't say left or right.
Okay, well, the problem is we have to know what you saw, and we can't rely on what you assume. So did you see her put it to the left of the trolling motor or
Yeah,
not?
it would be to the left, because if she went to the right, it would not been in the boat.
Ah. And so if she's reaching to the left of the trolling motor, when she falls, wouldn't she hit the bow of the boat as opposed to the trolling motor?
She hit both things, sir. She was stepping forward onto this. This is why her foot slipped. She was stepping forward. She had, and I'm not going to adjust. She had her foot here, and she was reaching to put that up because she was going to get down. I'm assuming because I didn't ask her, but there's another bucket right here of other things that needed to go up in the boat, so that when she was up in the boat, she could just offload everything that she needed.
Do you remember what the question was?
No, sir.
Wouldn't it be more realistic and logical for her to hit the bow of the boat as opposed to the trolling motor if what she's setting down is to the left of the trolling motor?
In your opinion, sir? I
No,
know
I'm
it
asking,
is.
I'm asking your opinion, ma'am. Wouldn't that be more logical and realistic?
No, not in the situation that I witnessed.
Okay. And so after did she hit both the trolling motor and the bow of the boat, or just the trolling motor?
She hit like this. She came down and she caught herself. She's probably here. She probably has a bruise on the elbow too. The way she came down, because she was stepping forward here. This foot slipped out and she just came down.
Okay. And she just came down where?
Right here at the bow of the boat. So the point of the boat's here, with the trolling motor over here. She fell right in this area. Her foot slipped. It actually slipped out this direction, and she came down.
I get that. I'm just trying to figure out if she fell on the trolling motor or the bow of the boat.
Council, I'm going to interject, because you have a sense of, I was letting it go because I thought you were here at the end, but we're after 5 o'clock. Should we continue the cross-examination
I
tomorrow?
don't think I have much more to go, Judge. If you want to wait another 5 minutes.
Is that doable? Okay, all right, let's finish it up then.
Trolling motor, bow of the boat, where'd she fall?
She fell and hit the bow of the boat and the trolling motor, sir. I don't know what else I can tell you.
Now, you've talked to us that you were closer to Kendy than Dan. Do you remember that?
Yes, sir.
But didn't you end up getting very close to Dan after Kendy's?
We have become
Yeah.
acquaintances. I'm Brett's girlfriend, so when Brett goes over, and so yes, sir, I've gotten to know Dan.
And haven't you assisted Dan in rounding all Kendy's stuff up and getting rid of it?
Objection outside the scope of cause.
Goes to bias.
Who's biased all about?
I didn't round up her stuff. Chris had brought me things downstairs, and I helped organize the pants and things that went to a consignment.
So you helped sell Kendy's possessions.
I didn't sell them, sir, but yes, I did help organize them.
Did you help get rid of her chickens as well?
No, sir.
You didn't have any part in that?
No, sir.
Did you have any part in making sure Brooke didn't get any of Kendy's possessions?
I had nothing to do with what the family did.
You mean Dan? Is that what you mean?
Yes, sir.
Dan had a part in that. Is that
Yes,
correct?
sir.
You have to say what you mean out loud because a court reporter is taking down your speech.
I had no relevance to what Brooke was given or not given.
I
sir.
get that. And my next question was, that was up to Dan Howard, wasn't it?
Yes, it was.
No further questions.
Maybe redirect it,
I don't have just a few questions if we can.
Okay, go ahead.
You were asked about before, he showed you a picture with timestamp of 15th.
Yes.
Remember him asking that?
Yes, sir.
And he asked you a bunch of different questions. Did the incident occur before the surgery that you mentioned with the 13th?
Yes, sir. It happened before the appointment, before the surgery.
When you're saying that, so you don't know when they actually left?
I don't know when they actually left.
And then on that picture of the boat, that's a picture from the front angle, correct?
The one that I was pointing at?
Yes.
It's not really a front angle. It's off to the side because if it were a front angle, we would be able to see the point and the trailer and not the step.
But it's not a good profile view?
No.
Okay. I have no questions.
Thank you. Thank you. Now you can sit down. We will be in recess at this time. Thank you for your patience and your jury. I'll excuse you and remind you, of course, not to discuss the case among yourselves or anyone else. We'll be back tomorrow at 9 o'clock. All rise for the jury. Take recess. Thank you.
You say I make you nervous, a tragedy, I'm a beautiful disaster, a reckoning. You wonder how I